right, good morning, everyone, and welcome to the Committee on Veterans and Legal Affairs this morning. We have a quorum present, and we'll call the meeting to order. We're meeting electronically to consider legislation that's pending before the committee. Before we get started, we'll begin with committee member introductions, and we'll start with the House Chairman Chiazzo.
Good morning. Thank you, Mr. Chair. My apologies. I got to mute my other computer that's on the live stream. Good morning, everybody. Chris Chiazzo, House District 28, beautiful Scarborough. Nice, sunny, warm spring day today. Hope all is well with you all as well.
Senator Farron.
Good morning, Mr. Chair, members of the VLA. My name is Brad Farron, the public out there. I live in Norwich Walk on the banks of the Kennebec up here this morning, representing Senate District 3, which is the majority of Somerset County.
Senator Hickman.
Good morning, everyone. TGIF. The garlic is poking up through at 5 inches tall. It's spring. I'm Craig Hickman. I represent Senate District 14, 11 towns in Kennebec, southern Kennebec County, including my hometown of Winthrop.
Representative Kinney.
Good morning, I'm Representative Marianne Kinney. I represent House District 99, where the eagles are in plentiful abundance this morning, right out my window. Nice view, symbol of our freedom, national bird, love it. Love having them on our farm. And I represent House District 99, Brooks, Barnum, Freedom, Jackson, Knox, where the eagles are plentiful, Monroe, Thorndike, Troy, and Unity.
Representative McCrate.
Good morning. I'm Jay McCrate, representing Harpswell, West Bath, and Northeast Brunswick in the House.
Okay, Representative Wood.
Hi, I'm Barb Wood, and I represent House District 38, which is the western end of the peninsula in Portland.
Representative Tuttle.
John Tuttle, House District 18, part of Sanford. Good morning. And it's cloudy in Sanford. I don't know what's going on.
Representative Riley.
Hi, Representative Morgan Riley. I represent House District 34, which is part of my hometown of Westbrook.
Representative Supika.
Good morning, I'm Laura Supika, and I represent District 126, a portion of Bangor.
Representative Corey.
Good morning, I'm Patrick Corey, I represent House District 25, which is part of Wyndham.
Representative Dolliff.
Good morning, Joseanne Dolliff from District 115, which represents Roxbury, Rumford, Milton Township, Woodstock, and Sumner. And I have stuff coming out of the ground. It might not be garlic, which I love, but my flowers are coming out.
Nice. Feels like spring. And my name is Louis Lucchini. I represent most of Hancock County in the Senate. Did I miss any committee members? My squares jumbled midway through that. Okay, we also have with us our committee analyst, Janet Stocco, and our committee clerk, Karen Montel. So before we get started with the public hearings this morning, we'll go over a few of the, ground rules for electronic committee hearings. So as a reminder, this committee is currently being live streamed on the committee's YouTube channel. This means that anyone who is a participant in the meeting via Zoom can be seen and also heard if their microphone is unmuted. People in the Zoom meeting waiting to testify in the attendees room won't be seen or heard until they're called upon to speak. And it's important to note, as we bring you into the panel, it may look like you're being dropped for a second and you may lose some sound, but just be patient, and once here, you'll be able to unmute yourself and turn your camera on. As another reminder, the audio for this meeting is being live streamed as always on the legislature's website. We're also able to take written testimony, and it's publicly posted on the legislature's website as well. Regarding the chat function of the Zoom meeting, this is a reminder that that's for technical assistance only. It's not for any substantive work. And for our bills today, we'll begin with the sponsors, followed by those who registered to testify, and we'll move through those by people who've registered to testify in favor, followed by those in opposition, and finish with those who are neither for nor against. For members of the public, when you're called upon, please state your name, your place of residence, in the organization you represent, if any. Only remarks on the legislation before us are considered in order, and a reminder to everyone that we use a 3-minute time clock. So please tailor your remarks accordingly. So in terms of the agenda today, we've got 4 public hearings this morning, and then we'll take a break and then go to work session after that. But today we'll begin with LD 818, an act to limit spam texting. Then we'll go to LD 914, an act to meet the state's obligation to pay 55% of education costs. We'll go to LD 916, an act to protect data privacy and security in elections. And LD 1178, a resolution proposing an amendment to the Constitution of Maine to prohibit the consideration of a people's veto at a presidential primary. So with that, we will recognize, or I'll open the public hearing on LD 818, an act to limit spam texting, and we'll recognize the bill sponsor, Senator Rafferty.
Good morning.
Good morning, Senator.
Thank you very much for having me join you today. So, Senator Lucchini, Representative Chiazzo, and distinguished members of the Veterans and Legal Affairs Committee, I'm Joe Rafferty, and I proudly represent all the people of Senate District 34 in the Maine Senate, and I'm here to present LD 818, which is an act to limit spam texting. LD 818 came to you as a concept draft centered around spam texting, which essentially came to my mind last fall as I was barraged on a daily basis with texts, calls, and emails. Most were tied to an election, and the rest were from sources I had either no tie to nor any interest in. I made a promise to myself that should I get elected, I've got to be able to stop this in some way or control it. Ultimately, I was elected, and hence the birth of LD 818. These were my thoughts on the LD, what it should contain. And I just, first I thought that it must first have an opt-in by giving my consent. And that consent, regardless of the method used, must be explicit, transparent, and comprehensive for customers to agree to the conditions. Once I consent, I would expect to get a confirmation text outlining what I consented to. I must also be able to have an opt-out option, and then provide me with the right to access my personal data to know exactly what it was they had, and an explanation of how or what my personal data is being used for. And I think it should be also include a notification mandate that I would know within 72 hours of the discovery of any data breach. To date, I really have to say that I've liked to have worked on this a lot more than the concept draft, more than I have, and because it's an important issue worth taking up. I also understand there may be some federal laws that may need to be considered as this bill is reviewed and considering its legislation. But I am willing to be an available resource to refine the bill into something more robust. I've heard from several constituents concerned about this issue for a while, and I imagine some of you likely have on your own campaign trails. I think the idea of the bill is still valuable and would love the opportunity to work with you all on it. And again, at this point, I still have not gotten beyond the concept draft itself. But I would like to thank you for listening and remain open to any suggestions in terms of moving forward at this time.
Thank you, Senator Rafferty. Any questions from the committee? Senator Farren.
Yeah, thank you, Mr. Chair. Thank you, Senator Rafferty, for bringing this forward. I know you mentioned that you haven't had a chance to put more effort, into this. We're all busy running through, but you also know we're kind of under the guidelines to move some of these bills forward and do that. Have you got a timeline in mind, maybe, of when you might be able to get some further language and something that the committee can actually chew on and work on?
Well, I know every time I look, I kind of discover a little bit more but my concern is trying to work within the so-called federal laws and that currently exist. And unpeeling those has been difficult, but I think if I can get a couple more weeks on it, I would appreciate that if you folks are willing to give me that time.
Thank you, Mr. Chair. Thank you, Senator Rafferty.
Thanks. Any other questions from the committee? Seeing none, thank you, Senator Rafferty, and happy to work with you on developing language if we can before the committee session wraps up.
Thank you, folks, very much. I appreciate your time and patience.
Great. Thanks. Okay, so regarding LD 818, we don't have anybody signed up to testify on this one. So I'll just do a last call of anybody in the attendees room. If you'd like to testify, just raise your virtual hand. So seeing none, I'll close the public hearing on LD 818. So the next bill, we're just going in numerical order, is LD 914, an act to meet the state's obligation to pay 55% of education costs. And the sponsor for this one is Representative Tuttle. Welcome.
There we go, Mr. Chairman. I finally did it right. When I put this bill in, I didn't know which committee it was going to, either education or here, but I'm sort of glad it's here back in VLA. But Senator Lucchini and Representative Chiazzo and fellow members of the Veterans and Legal Affairs Committee. As you know, my name is John Tuttle. I am a state representative from District 18 in Sanford, and I am the sponsor of LD 914, an act to meet the state's obligation to pay 55% of education costs. In 1973, when the lottery was first presented to the legislature, it was sold under the premise that 100% of the revenue would be used to fund K through 12 education, which was never done. 10 years ago, when Senator Lucchini and I were renegotiating the liquor contract as chairs of this committee, there was talk about using some of that revenue to meet the 55% level of education costs voted by the people of Maine overwhelmingly, which was never done. Instead, we worked with Governor LePage to fund rural hospitals like my own in Goodall and Sanford, who were experiencing financial hardships and fear of closing their doors. So the money was sent to assist the hospitals. 10 years later, those same small hospitals like mine have been absorbed by the bigger hospitals, and all the prices have seemed to increase 2- and 3-fold. This is a national phenomenon exposed by the news program 60 Minutes. This bill provides that funding for 55% of the total cost of education by applying up to 100% of all lottery and alcohol revenues towards the total cost of education. While this is a novel idea, in all honesty, Mr. Chairman, I think the passage based upon our financial situation presently is probably slim. So I'd request that we would amend this bill and probably have to change the title to direct the VLA committee to do a 10-year review of liquor and lottery revenues and report back to the second session of the 130th legislature with their recommendations. I think that would be appropriate thing to do, something we've done in the past, and I think would be fruitful for all members of the committee to address liquor and lottery revenues every decade. Thank you, Mr. Chair.
Thank you, Representative Tuttle. Any questions from members of the committee at this time? Representative Wood.
I can't.
You're unmuted now already. So, yep. Oh, now you're muted though. You're good now.
Okay.
Yep.
I just, Representative Tuttle, at the end, you said a review of liquor revenue, lottery revenue and liquor revenue. So I just wasn't expecting to hear the liquor revenue piece. If you could just speak to that.
Well, Bob, every 10 years, I think we do review both aspects from this committee. So I think it would be better if, as a committee, we would review both revenue, and if we want to make some changes based upon a decade of change, I think I know I talked to leadership before I put this bill in, and there had been some discussion that they had interest in doing this, but I would prefer it being done by the committee of jurisdiction and not necessarily just certain members of leadership.
Oh, okay. Thank you.
Right. Any other questions for Representative Tuttle? Okay, seeing none. Thank you for presenting your bill. Okay, next we'll move to the public hearing portion again for members of the public. If you remember to state your name, your residence, and the organization you represent. And again, we do use the 3-minute clock if you can tailor your remarks to that. So based on the registration form, we have John Kaczynski. He'll be followed by Victoria Wallach. And we have Holly Couturier. I'm not seeing in the attendees list. So we'll start with John when he's ready. Welcome.
Hello, Senator Lucchini, Representative Caiazzo, and other esteemed members of the Veterans and Legal Affairs Committee. My name is John Kaczynski. I live in Brunswick, and I'm here to testify on behalf of the Maine Education Association, neither for nor against LD 914. And I just heard Representative Tuttle speak. So I'm not sure based on what he just said, I'm not sure my comments are particularly relevant, but I would like to hit just a few points. We appreciate Representative Tuttle bringing this bill forward. Obviously, the MEA remains steadfast in our commitment to see the state finally realize the goal of 55% state funding for schools. As Representative Tuttle mentioned, this was passed in 2004, yet every 2-year budget, we have notwithstanding language included that continues to push this goal further away. The state is currently funding about 52% of the cost of public schools, so we're getting closer, we're inching up that hill. But when we don't fund our schools properly, we all know that property taxes are forced to increase in order to make up for that deficit. And in addition, it builds inequities, more inequities among our public schools around the state. So 55% remains a goal that we're committed to, and appreciate Representative Tuttle's views on this. I will say this bill in particular struck a special chord with me because in 2016, I ran the Stand Up for Students campaign initiative that was designed to increase taxes on the wealthy to finally fully fund our public schools. We saw this as another iteration of voters approving the 55% and in fact approving a way to get there. Unfortunately, the tax portion of that was repealed by the legislature and the governor, as some of you may remember, in 2017, and we still fall short of the 55% requirement. When I ran that campaign, I will say I went out to a number of community events and community forums, and I loved going to them. But one question always came up. What happened to the lottery? There was this assumption that lottery revenues were going to public schools. And I think this is pretty typical. We see this in ballot initiatives where organizations say, if we pass this casino, it'll mean more money for schools. But what that really means is more money for the general fund. And we still haven't met that threshold of getting to that 55%. We are nervous about the original version of this bill because we all know our state budget is tight. And taking money from lottery or alcohol will just mean a shifting of resources within our state budget. So we just had concerns about that, but appreciate the sponsor's initiative to maybe look at these two revenue streams, both lottery and alcohol, to see if there might be a way to use those monies to support our public schools going forward more robustly. Thank you for your time, and I'm happy to answer any questions. Got it right in time, Representative Cayazzo.
Thank you for your testimony, Mr. Kaczynski. Any questions from the committee at this time? Seeing none, thank you.
Thank you very much.
Okay, next we have Victoria Wallach, and she'll be followed by Anya Trundy. Welcome.
Good morning, everybody. Senator Lucchini, Representatives Chiazzo, and members of the Veterans and Legal Affairs Committee. I am Victoria Wallach, Communications and Government Relations Director for Maine School Management, testifying on behalf of the legislative committees of the Maine School Boards Association and Maine Schools Superintendents Association in support of LD 914. We support the intent of this bill with all the caveats that have already been mentioned. It would provide a very robust stream of revenue to support public education. Other states do this, as you know, and as was mentioned by Representative Tuttle, it was way that the lottery was sold at the time in this state, was that it would be dedicated to education. I did some Googling around, and most recently, California was called out for shorting the state's public education system with its lottery sales by $36 million. They raised $1.7 billion on lottery sales. Obviously, we wouldn't be in that ballpark, but other states, including smaller states and big states like California, do this. And mentioned it would also designate a portion of the tax on alcohol. We assume, as mentioned, that this bill will have a sizable fiscal note, and because the money is currently going into the general fund. But we appreciate and support the bill's intent, and it also, as Mr. Kaczynski said, puts the spotlight again on the fact that we're not at 55%. We're at 51.8%. And as you know, the cost of education goes up every year. And so that it becomes an elusive goal unless we really create some serious cash to it. So, or dedicate it. And I'd be happy to take any questions. Thank you.
Thank you for your testimony. Any questions from committee members at this time? Okay, seeing none, thank you. Oh, sorry. Well, technically Representative Tuttle as the bill sponsor. Yeah.
Okay, I agree. Thank you. Okay, Mr. Yeah, really.
Sorry.
Yep.
Yeah. Okay, thank you for your testimony. All right, next up we have Anya Trundy from DAFS. Welcome.
Thank you. Senator Lucchini, Representative Chiazzo, members of the Joint Standing Committee on Veterans and Legal Affairs. I'm Anya Trundy, Director of Legislative Affairs for the Department of Administrative and Financial Services, and I am before you today to provide testimony on behalf of our department, neither for nor against LD 914. DAFS is home to both the Bureau of the Budget and the Bureau of Alcoholic Beverages and Lottery Operations. Bablo is extremely proud of the state's liquor and lottery businesses' strong performance. They've both grown to generate approximately $60 million in profit annually, or $120 million combined. But when we talk about the state's contribution to the cost of education, we're talking in billions, not millions. In the recently passed FY 22-23 budget, the state increased its share of school funding to 51.83%, the closest we've ever come to meeting the state's obligation to pay 55% of education costs. For FY 22, the state's contribution to the total cost of funding public education from kindergarten to grade 12 is $1.236 billion. That's just for FY 22. The state's contribution to the total cost of funding public education from kindergarten to grade 12, plus the state's contribution to the total cost of unfunded actuarial liabilities of the Maine Public Employees Retirement System that are attributable to teachers, retired teachers' health insurance, and retired teachers' life insurance is $1.48 billion. For FY 22, the state appropriated 10 times the amount toward the cost of education than this bill would dedicate in liquor and lottery revenues. Education is the most significant piece of the state budget pie. The dedication of liquor and lottery revenues isn't capable of meeting the 55%. All general fund revenues are part of continuing to make steady progress toward achieving that goal. Additionally, I would ask you to weigh the fact that when we dedicate funds in statute for today's priorities, we eliminate flexibility and limit the revenues available to fund the shifting priorities of the future. Thank you for allowing me to testify, and I'm happy to answer any questions you may have.
Thank you, Ms. Trundy. Representative Wood.
Thank you, Mr. Chair. Anya, did you say I did hear you say at the very beginning that there's $120 million worth of profit from both streams from Bablo, correct?
That's an approximation, but both businesses yield about 60 million each in profit annually, and those are numbers that they've both grown to over time. But I think that we would expect them to be consistent from here on out.
And does that, I don't know how it all works yet. I'll figure it out before I'm done. Does all of that just go straight into the general fund?
It doesn't all go straight into the general fund. The lottery revenue goes to the general fund. On the liquor side, there's a cascade currently that was attached to the past liquor contract. And if initially it was intended to fund the hospital debt, that debt has been paid off. It funds a couple other things before being held in account for the main municipal bond bank. And in the past couple of budgets, we have transferred money from the main municipal bond bank to the general fund so that those excess funds weren't just sitting in the bond bank and they were actually used for current funding needs.
Lastly, if there were a lot of numbers that you went through that I thought were really interesting, but I couldn't keep up with all of them. If you can provide that in writing.
Yeah, absolutely. Yep, my testimony is submitted in writing.
Okay, thank you.
Great. Chairman Chiazzo.
Thank you, Mr. Chair, and thank you, Ms. Trundy, for being here this morning. Excuse me. So you mentioned the approximately 160 million in revenue or profit, if you will, from the two organizations. To get us from 51% to 55% is obviously going to require a lot more than that, I'm assuming. Is that a fair statement?
Well, I think at this point, those funds are part of the mix that goes currently towards funding, getting us to that 51+% right now. I don't know. I don't know as the dedication could promise getting us to 55%. I think like Mr. Kaczynski brought up, it's a matter of shifting funds for shifting priorities.
Yeah, I guess my point was even if we took all of that revenue and took it all away and dedicated it just to education, we still probably would not hit the 55%.
I don't think so.
Right. Yeah. Okay. Thank you.
Great. Any further questions for the committee at this time? Okay. Seeing none, thank you. Ms. Trundy.
Thank you.
Okay, at the moment, that concludes all the people who have pre-registered to testify on this bill. We'll do a last round of people in the waiting room if there's anybody here who wish to testify for this. Okay, seeing none, I'll close the public hearing on LD 914. Okay, the next bill on our list is LD 916, an act to protect data privacy and security in elections. And we'll recognize the bill's sponsor, Representative O'Neill. I think we're just bringing her into the room now. So welcome, Representative O'Neill.
Thank you, Mr. Chair. Good morning. Senator Lucchini, Representative Chiazzo, and members of the Joint Standing Committee on VLA. My name is Maggie O'Neill, and I represent House District 15, which is in Saco. So thank you for the opportunity to present LD 916, which is an act to protect data privacy and security in elections. I introduced this bill at the request of the Department of Secretary of State. Together, we submitted a pre-cloture vehicle, and the department has since developed this information privacy proposal. The department is available here today to answer your questions about the details. And I'll just close by saying elections and election cycles have become increasingly dependent on data. However, securing the privacy of voter information must be at the forefront of practices regarding data collection, storage, and use. So this bill strengthens our safeguards in order to protect the privacy of Maine voters and to ensure that voter information is kept securely. So I thank you for your consideration, and I will pass it off to the department to describe it.
Great. Thank you, Representative O'Neill. Any questions from the committee at this time? Seeing none, thank you for your testimony. Okay, so we'll register to sign up for this bill. We will move to Secretary of State Bellows. Welcome.
Hi, Senator Lucchini, Representative Chiazzo, members of the Veterans and Legal Affairs. I am Shanna Bellows. I am Secretary of State, and it is my deep appreciation to Representative O'Neill for sponsoring a vehicle that has allowed the department to move forward in protecting data privacy and security, to ensure that the personal data of Maine voters is protected and make certain such data is not accessed by the general public on the internet. The amendment that, and I apologize, you received this morning, or your clerk just received this morning, but it does three things. It clarifies that no entity receiving the voter file may cause information contained in or derived from the data that identifies a specific voter, including the voter's name, street address, and mailing address, to be made available on the internet in a manner that can be accessed by the general public. It allows restricted access to voter information for organizations seeking to evaluate the state's compliance with its list maintenance obligations under the National Voter Registration Act. It increases the enforcement authority of the state by attaching fines to violations of the statute. Securing the privacy of voter information must be at the forefront of election officials when collecting such data. As Secretary of State, I am very invested in and have prioritized this issue because I know unauthorized use of voters' personal information runs the risk of potential targeting and manipulation of voters and ultimately loss of confidence in democratic processes and institutions. According to a 2016 survey conducted by Pew Research, 11% of unregistered Americans chose not to register to vote, citing privacy or security concerns. It is vitally important that we prevent the potential disenfranchisement of voters and not discourage voters from participating in the voting process in any way. Additionally, we have a solemn obligation to Maine citizens to safeguard that data, to prevent unauthorized disclosure or publication of voter information that might compromise voter security or undermine the integrity of our elections through voter fraud. Increasing the statute's clarity about disclosure and authorized use reduces the danger of inappropriate disclosure or use. Creating a penalty for violation of the statute improves the state's ability to protect the privacy and data security of Maine citizens. Under the National Voter Registration Act, states are obligated to comply with certain requirements regarding voter list maintenance and registration. We've talked a lot about that in this committee, and in Maine we do uphold those obligations. However, the data that we house is personal, protected information. It's incredibly valuable and should be protected. By limiting access to voter information to efforts directly related to a candidate or a campaign, or to purposes directly related to evaluation of list maintenance activities, this bill would decrease the odds that potential identity thieves or stalkers would be able to access the data for nefarious reasons. This amendment seeks to advance data security and privacy by increasing clarity around disclosures and tools for enforcement. I thank you for your consideration. Happy to answer any questions, and we may have some future tweaks to this amendment for the work session. It's something that we've been working very closely with the Attorney General's office on.
Thank you, Secretary Bellows. And so you did just send us the language?
Yes, and I apologize that you got it. So we sent it, I think, after the hearings had started this morning.
Okay.
For some communication on our side, so.
Great. And did you submit written testimony? That might be helpful as well, just to explain.
Yep. Similarly, we submitted that around 9 a.m. I apologize.
Okay. Thank you. Representative Corey.
Thank you, Mr. Chair. Are there examples of this information being publicly sort of available? It seems like the bill tries to make it so that this information wouldn't be publicly available, but are there actually examples out there of situations where people have made this information publicly available when it's not supposed to be?
Sure. There have been incidents of voter doxing in other states where information about who has voted or hasn't voted is released, and that is a concern that we're seeking to address. We want to
go ahead.
Supply those for the work session. I'd be happy to.
Yeah. Okay, great. Like the articles and stuff like that,
Sure.
the actual incidents themselves. Thank you.
Yep. We can prepare a memo of unauthorized disclosure of voter information in other states. And to be clear, this has not happened in Maine. We're not seeking to correct a problem that's happened in Maine. We're just seeking to be as protective as possible.
I guess kind of to follow up on Representative Corey's question, I remember a few years ago, we got a lot of complaints from people who'd received letters from groups that would list every time they voted and say they were going to make it public if they didn't vote again. Is that a similar type of thing, or?
That is, forgive me, I'm not familiar with that. That was prior to my tenure as Secretary of State, but that is a type of behavior that would certainly be concerning to us. Groups should not be making any threats to voters, either to vote or not to vote.
Okay, yeah, I'll try to see if we can find some of that, because I think we did get some complaints.
I'm sure Deputy Secretary Flynn perhaps remembers as well. We can provide that to the work session as well.
Great, thanks. Any other questions for Senator Hickman?
Thank you, Mr. Chair. In the most recent election, there was a postcard that was sent that did say that your voting record is public. Here is your voting record, and we'd like for you to vote. Is that something that would run afoul of this new law, or was that even a problem to begin with?
I need to reflect further on that question and bring it back to the Office of the Attorney General and think through. I think that we want to be very careful not to be discouraging voters from participating and disenfranchising voters through perceived or actual threats. So let me reflect on that question and consult with the Office of the Attorney General.
Thank you.
Any other questions at this time? Great, thank you, Secretary Bellows.
Thank you.
Okay, so next up on our list to testify on this bill, we have Luke Siebert, who is testifying in opposition to this bill.
Thank you to the committee. I'm going to yield my time today. I apologize for the inconvenience. Thank you all.
No problem. Thank you. Okay, is there any other people in the attendees list? That's all we have who have registered to speak on this. But if there's anybody else who's here for this bill, if you can raise your virtual hand, we'll call on you. Otherwise, we'll move to the next bill. Okay, seeing none, I will close the public hearing on LD 916. And we'll open the public hearing on the last bill on our list for this morning session, LD 1178, resolution proposing an amendment to the Constitution of Maine to prohibit the consideration of a people's veto at a presidential primary. And the sponsor is Representative Corey. Welcome.
Right. I didn't think I'd be up so quickly. I didn't have time to finish my testimony. I'm just joking. I wrote it last night. So here we go. So Senator Lucchini, Representative Cazo, and members of the Committee on Veterans and Legal Affairs. I'm Representative Patrick Corey of Wyndham, and I'm testifying in support of LD 1178, a resolution proposing an amendment to the Constitution of Maine to prohibit the consideration of a people's veto at a presidential primary. As you will see from 1178 summary, this bill is fairly straightforward. The resolution intends to prohibit the consideration of a people's veto at a presidential primary election. In June of 2019, the Maine legislature passed LD 1626, which implemented a presidential primary system in Maine. I'm not blaming this on Senator Lucchini for having sponsored that bill because nobody could have foreseen this problem coming. That following year, we held a contested Democratic presidential primary. Even though we hold presidential primary elections every 4 years, there are some factors to determine whether or not they will be contested election, which includes whether or not the seat is open or if the incumbent is unopposed. These factors greatly impact voter turnout, which can influence the outcome of a people's veto process if it is held in the same cycle. In 2019, there were different groups opposed to some of the actions of the 129th Maine legislature. These groups planned their people's veto campaigns based on incorrect information provided by the Secretary of State's office. They were told that the people's vetoes would be considered during the June primary. After these groups had signature collection efforts underway and had spent money, they were informed that voters would weigh in during the new presidential primary in March. Some groups halted their efforts while one pushed ahead. Why does this matter? In any cycle, it is important to capitalize on voter engagement and participation, which is why significant monies are spent for get out the vote efforts during a contested election. In March 2020, we saw a contested Democratic presidential primary and an uncontested Republican primary, which also coincided with the people's veto. In the contested Democratic primary, over 200,000 registered Democrats showed up to vote, while only 113,000 Republicans voted in the uncontested primary. We need to consider the potential momentum one party has over another during a contested primary election and how that can influence the outcome of any referendum. In the scope of the people's veto, political efficacy was negatively impacted by changing the date in which it would be voted on the same day as the Democratic presidential primary, as evidenced by signature gathering efforts halting. I hope that we can all agree that the people's veto to be effective, voter participation is necessary, and that we want to hear from a cross-section of Maine's people. This legislation ensures fair and consistent process. The process holds the same, whether it is a presidential election year or not. An unintended consequence of passing the law implementing presidential primaries was the influence it has on the people's veto. The people's veto or referendum were signature reforms of the progressive era, focused on direct democracy or citizen rule, as was the presidential primary. With that said, we should not let the people's veto fall victim to another presidential primary as we did in 2020. I'll leave you with this. Back in 2019, when this problem arose and I became interested in it, the Bangor Daily News editorial board wrote that I'm appropriately focused on the process concerns here and not the politics. They went on to say, the right thing for all involved here is to wade through the admittedly complicated procedural and constitutional layers and try to find a way to address this unintended consequence, not only in fairness to the existing people's veto and the people working on them, but the integrity of the process moving forward. We did not fix this issue in 2020 when we ran the people's veto during the presidential primary. We have an opportunity to correct this for the future. During my legislative service, it's always been my experience that when we enact laws that have unintentional consequences, we fix those laws. I understand this comes with a fiscal note, but I feel this is part of the cost of having presidential primaries in Maine. Thank you for your consideration, and I would be happy to answer any questions you may have. I just really want to quickly say that, this was like I said, this was a Democratic, contested presidential primary in 2020, but that doesn't mean in 2024 that, there would be more maybe Republicans showing up to a presidential, primary in that year. So I feel like this affects, both parties equally. And the other real concern I have here is that, if we're having, these people's vetoes during, contested, party primaries, other than that people's veto, what's really getting our huge number of unenrolled, voters out to the polls during those elections. Anyways, I appreciate your time, and I'd be happy to answer any questions.
Thank you, Representative Corey. Representative Wood.
Thank you, Mr. Chair. Representative Corey, you mentioned that it will probably come with a fiscal note. I just wondered what would cause it to have a fiscal note?
Oh, that they have to print an extra page, like a ballot page, to go out on the ballot, because it's a constitutional change. So, if this, makes it through a 2/3 vote in the legislature and it goes out to the people to vote on, then it's only the cost of what it would be to, put this question out to the voters.
I was thinking that you were saying that there was some cost in the future to not have it part of the presidential primary, but I get it now. Thank you.
No, and the thing is, if there's other constitutional amendments that go out to the people that are on that same page, then that all gets divided between all of those different constitutional amendments. It's that cost then is split up based on that page.
Thank you.
Great. Any other questions for members? Representative McCray.
Thank you, Mr. Chair. Representative Corey, am I understanding you're making 2 points here? One is when this was a new process, there was confusion about when the vote would happen.
Yes.
As a separate issue from the imbalance if one is contested and one isn't. Am I understanding correctly?
Correct. So basically, the big concern, at least with those past elections or those past people's veto efforts, they felt, at least I think that, a lot of those campaigns, that they would have had a fair shot at the polls if there was a bigger cross section of Mainers that were involved on that election date. So they halted their, efforts, based on, having been told that it would be in the June primary, but that it actually happened in the other primary. What was the second part of that question?
Well, that was one piece that I'm assuming is largely because it was new, but
yeah,
you didn't. And the other part was the real core of what you're trying to do, to say that because a presidential primary might be contested in one and not in the other, you want it not to happen during a primary to prevent an imbalance of how many people vote.
Yeah, I think when we have these types of things, I think that probably, a hallmark of the progressive era was, that we wanted, broad citizen participation in elections. We talk about that all the time in this committee. So I think that this just assures that, that we have the broadest, possible, participation. That doesn't mean, that it's lopsided to one party or another, but, everybody has a reason to get out to the polls on those specific elections. I know even during the June primary, and it's something that committee might want to consider, that, there are times where, people are making a gubernatorial choice on those June primary years. And, we might actually want to consider whether or not, that's the best time to do it, because obviously, if you've got an incumbent, you don't have a primary on one side, and granted, all of us nerds are on the ballot at that time as well, trying to, but we're just little us, so I don't know if we drive the people out there, but I know that those gubernatorial races can, as well, whether or not they're contested or not. So I don't know. I probably shouldn't have just called us a bunch of nerds, but I'm good.
Great. Any other questions at this time? Right, seeing none, thank you, Representative Corey. So I don't have anybody registered to testify that I can see, but if there's anybody in the attendees list who wishes to testify on this, if you can raise your virtual hand, we'll give you a chance to speak. Okay, seeing none, I will close the public hearing on LD 1178. Okay, those 4 bills went faster than anticipated. So we'll take a recess. The committee will recess. Our schedule says we'll begin work sessions at, apologies. Our schedule says our work sessions will begin at 11 o'clock. So we will take a recess until 11. The same link will get you back into this one. So if there's nothing else, okay, we'll see everybody back in an hour.
Hi, Representative Riley.
Okay, we'll bring in a few more members and then we'll get started with the work session this afternoon. Okay, we'll get started. Welcome back, everybody. This afternoon, we've got 4 bills scheduled for work session. And I think we got a couple of items that came up from the revisor's office for language review, which we'll do at the end. So this afternoon, we have LD 194 and 479, which are both related to foreign contributions to Maine elections. We have LD 670 related to lobby registration fees. And we have LD 1126, which is related to online voter registration. And so we'll begin with LD 194 and LD 479. We've had a couple of work sessions on these initially 3 bills and now down to 2. We have some people in the attendees list who are available to answer questions as well if committee members want. I've also put together an amendment that I sent out to the committee members, which may be, I guess, a good way to start if people are good with that, just to get discussion moving on the bill. And Janet sent that out to everybody this morning, just as some options, but it's not, it doesn't go as far as every bill, and I don't know how far committee members want to go, but I think as a starting point for discussion, it may be a good place to go as we've gone through some of the charts before. So, Janet, do you have that amendment available?
Certainly. Trying to figure out how to zoom on this.
Yeah, no.
Okay.
Yeah, and as we go through, if anybody has any questions, just raise your virtual hand if you can, because I can't see you all when we're in this format. So you can raise your virtual hand and then we can elaborate on any of these issues, obviously, to wherever the committee wants to go.
Okay. So Senator Lucchini's proposed amendment is to LD 194, which is Senator Bennett's bill. Yes, just checking. So in the middle column here, you'll see what Senator Lucchini proposes to have the bill amendment contain, and then to the right are some notes to hopefully help explain what that means. So his amendment would apply all foreign national prohibitions just to state and local referendum elections. Senator Lucchini directed me that this was because he would rely on the federal law for candidate contribution prohibitions by foreign nationals.
Right. And Janet, sorry to jump in. So just so everybody knows, I just kind of built off that initial chart that Janet had given us that broke down each bill as well as federal law, which was very helpful in trying to break down each of the decision points that the committee will have for those who wish to move ahead. And thanks to Janet for putting it just in bullet point format so it's easier to kind of see, and then we can move forward however. So sorry to interrupt, Janet.
No, anytime, it's your amendment, not mine. I just wrote it down. So for the definition of foreign national, the first box here describes the definition, and that's the definition that matches the federal definition of foreign national. So it will include a foreign government, a foreign political party, an individual who's neither a citizen nor a permanent resident, and then entities that are organized under the laws of the foreign country or that have their principal place of business in a foreign country. Senator Lucchini wanted to go a little bit farther, however, and include the proposal that's in 194 as well, which is to include as a foreign national any entity for which a foreign government owns, controls, or has direct or indirect beneficial ownership of at least 10% of the equity or voting shares.
Sure, and I can just speak to my intention kind of on this is just simply to take that federal law that applies to us as state candidates. It applies to federal, state, and local candidates, and just apply it to main referenda. And then, as Janet said, it goes farther to get at corporations which may have a large ownership by foreign governments. Representative Bailey's bill goes further. I didn't include that in here, but that's obviously there as well for discussion, as well as the 10% is certainly movable to wherever the committee feels. And Senator Bailey's bill goes into beyond, I guess, foreign government ownership and just foreign national ownership at I believe a two-tiered approach with 5% and 20%. But sorry, Janet.
No, nothing to apologize for. As far as determining this 10% equity, there have been concerns at the work sessions and hearings. So Senator Lucchini directed me to include a provision. I'm not sure he's 100% sure on this, so I'm going to let him describe it after I tell you that, as I understood it, if an entity makes at least $100,000 in aggregate contributions or expenditures to influence a referendum, the CEO or the highest ranking official of that entity has to certify, subject to the penalty under state law for false swearing, that after due inquiry, the CEO or the highest ranking official believes that the entity was not a foreign national as described above on the date or dates that the entity made those contributions or expenditures. That certificate would have to be filed with the Ethics Commission and a copy provided to the recipient of any of the contributions, for example, a ballot question committee or a political action committee that's funding the referendum effort. They would get a copy of that certificate and they would be entitled to rely upon that in good faith. And just so that you know, the penalty for false swearing is a Class D crime. And because it's an individual, the CEO or the highest ranking official who's making the certificate, they would be subject to a fine of up to $2,000 and a term of imprisonment of less than 1 year should they be prosecuted.
Great, thank you, Janet. Representative Tuttle.
So Lucchini, where did you come up with this information? Is it something that you drafted yourself or was it from something else?
Yeah, thank you, Representative. So on this portion here, one of the reason why I developed it like this, and I was kind of working through it a little bit with Director Wayne, just on the practical application of the law. I think one of the difficulties if we, in reading through a lot of the testimony, they use the CEO affirmation or attestation of foreign ownership within their companies. The difficulty from a practical, I guess, perspective is that under current law, corporations can give to PACs and BQCs, and they never have to do any filing whatsoever. They just give they give the check to the PAC, and then the PAC will report it in their usual statements. So when we go to the step of US corporations that may be, or US organized corporations that could have ownership by a foreign government, in trying to do that CEO attestation, what we would end up doing is making every group who's incorporated have to file with the Ethics Commission, which is not what's currently done. So any, for instance, nonprofit who wants to give, and they normally do, would have to no longer just send a check. They'd have to file with the Ethics Commission and verify that they're not at this high level of foreign ownership. So what I did was try to mirror this off a major contributor law that we've passed a few years ago related to referendum. So these corporations would already be doing a filing with ethics based on the previous law that if you give over $100,000 to influence a ballot question, you have to list the sources of your income. And so from a practical perspective, we could very easily add that CEO affirmation onto that filing rather than make, blanket every company who wants to contribute at, however small. So I think this gets at the big issue of those really large contributors without creating a filing process that would hit every single corporation or nonprofit who gives within the election process currently. It was something I didn't even think of until, just trying to play it when I was talking with Director Wayne and trying to walk through how it would work.
Okay, thank you, Senator.
If that helps, yeah.
Okay, so for the definition of foreign national referenced above, all of those individuals and entities under Senator Lucchini's proposed amendment may not make directly or indirectly any contribution to influence a referendum, make directly or indirectly any expenditure to influence a referendum, or direct, dictate, control, or directly or indirectly participate in a person, that's usually an entity's decision-making process for making contributions or expenditures to influence a referendum. So these provisions are in current LD 194, but that bill has a smaller definition of foreign national, or narrower, excuse me, not smaller. And these are all similar to federal prohibitions for candidate campaigns. The only difference would be that there's a couple of technical issues in the LD 194 drafting that Senator Lucchini's amendment would address, just to make sure that the definitions of contribution expenditure have to do with ballot campaigns, not candidate campaigns.
Right. Thanks, Janet. And my thought is just that the federal law covers any contributions to candidate campaigns. So rather than repeating federal law and state statute, we just leave it with the federal law, because if the federal law were to change and we were unaware of it in state statute, then it wouldn't match. So
the next provision are the prohibitions against non-foreign nationals. So these would be sort of recipients of funds or American entities or persons. So those persons may not knowingly solicit, accept, or receive prohibited contributions from foreign nationals, knowingly provide substantial assistance to the foreign national in making, soliciting, accepting, or receiving the prohibited contribution, or knowingly providing substantial assistance to the foreign national in the making of the prohibited expenditure. And these are all similar to prohibitions under federal law for candidate campaigns.
Right. So again, yeah, just trying to match it up similar to the federal law on that.
Senator Lucchini also has an additional foreign national disclosure requirement. So if a foreign national makes a non-prohibited communication, so it's a communication not necessarily intended to influence a state or a local referendum, but so that it wouldn't be covered by the prohibitions above. But if they still make a communication intended to influence a state or local government policy or foreign relations, and they finance that communication, then the foreign national sponsorship would have to be conspicuously disclosed on that communication. And there is a provision in 479, it's subsection 7 of that bill that Senator Lucchini is referencing here. I just really summarized it in that little box.
Thanks. Senator Farron.
Thank you, Janet. Thank you, Mr. Chair. This is a lot to digest. I'm glad we're going through this line item by line item, and I appreciate the amendment, Senator Lucchini. One of the things, you know, I'm trying to wrap around, and I think this gets more in line with what we've talked about from a standpoint of making the referendum under the same rules as campaign for candidates. But if a company in Maine that has foreign interest but is based in Maine with Maine employees and is managed in Maine, how would that affect them from participating in say a referendum question? That's one of the things I just want to make sure, if they're controlled here in Maine and have Maine employees, that they still have some say in that.
Right, and I think that's the provision from LD 194, which Janet has moved up. There we go. Yep. So that would prohibit any corporation where a large percentage of it was foreign government owned, depending on what, if we were to move ahead and whatever number it is. With the 194, it was 10%. So if there was a company anywhere, I guess, in the US that was largely owned by a foreign government, they would not be able to participate.
So would you follow up? I'm sorry. Would this be in your amendment? And I don't have a number in mind, but maybe we could take a look at I don't know if there are specific companies in the state of Maine, but maybe we could look at that percentage being a little bit higher.
Yeah, I'm totally open to, you know, whatever the committee wants to do, and yeah, definitely potentially looking at it higher. I think the previous bill was 50%, and that's, yeah, I'm open to anything. I'm just, you know, obviously, yeah, we just try to build, see where people are. Yep.
Gotcha. You're good at that, sir. You're good at that.
Yeah, I don't know about that. Chairman Chiazzo.
Thank you, Mr. Chair. I also, I mean, I appreciate the amendment and the intention behind it. I guess my question would be maybe to Janet. We had talked a little bit earlier in the previous work session about how far out do we go in terms of establishing ownership. And my concern would be when you have the, you know, indirect beneficial ownership, how many layers removed? Does this address that in any form, or is it simply whatever the entity is, if it has let's say a fund invested in it as a proportional owner, it's where the fund's based, not who's invested in the fund. Does that make sense?
I think so. All I can tell you is that the way current federal law is written, as far as the entities are concerned, it has this definition. I'm going to set aside the foreign governments for just a second. And the federal law has this same prohibition on directly or indirectly making the contributions or expenditures. And so when the FEC looked at that directly or indirectly language, it engaged in rulemaking, and it has a web page. I can't remember if I just linked it or if I included it.
I looked at the definitions in the federal statute. I couldn't find anything that even specifically called out. It didn't get to the detail that we are here for sure.
Right.
Maybe I was just in the wrong spot. I don't know.
No, that's okay. There's a link here. I'll see if I can find it again and maybe email it to everyone. Okay. But the FEC, when it looks at those definitions, it passed a regulation that specified this, that said based on the indirect contributions and not wanting the foreign national actually to be in charge of its domestic subsidiary making those contributions, that if a foreign national dictated or controlled the decisions that were being made by a domestic subsidiary, for example, then as far as the FEC is concerned, that is a violation of the federal law, because that's indirectly controlling the making of that contribution. So that's one category of domestic subsidiary that the federal government believes is included in their definition. The other category is, for example, a domestic subsidiary of a foreign company where the domestic subsidiary doesn't have its own revenue or doesn't have sufficient of its own revenue to be the source of the funds that are being contributed or expended. So if you can't reasonably trace the money that's being contributed or used to influence under the federal government side, the candidate campaign, if you can't trace that to domestic money, if it's really coming from the foreign national, then the FEC considers that a violation because then the foreign national is indirectly contributing to the campaign. So I believe my understanding would be where it's clear the way that this amendment would be written, or as clear as I could make it if you directed me to draft this amendment, that we're following the federal definition. Those federal interpretations should come along with it. But just in case, because this whole directing, dictating, and controlling is in rulemaking, I think the idea with a bill that was put forward in the 129th and then the bills that are before you this session is to actually put this rulemaking piece right in the statute. So you can't control the decision-making process. So that will be clear that the foreign national can't, for example, have all of the seats on the board of the entity and they vote to make the contribution. And then because it's an indirect contribution is prohibited, if the money is all coming from the foreign national, then that would be an indirect contribution. I don't know how far that spins out. That's how far it spins out on the federal level. As far as this,
but by adding that rulemaking into the actual statute, we're going beyond the federal statute, because the federal statute has the basis in there, but the rulemaking is done by the agency, correct?
It is, but it's just as equally valid law as the statute at this point in time. So it would just be making that law.
It would be codifying the rulemaking in statute, not leaving it to the discretion of, let's say, the ethics commission or something to determine what that is.
Right. And I don't know how, I mean, I'm not an administrative law scholar, so I don't know how tightly they look at, is this regulation very obviously directly coming from this definition of foreign national and the direct definition of direct or indirect contribution? I don't know, but I think what it does is it gets rid of the possibility of that challenge if you feel like that's a problem. It's really up to you.
Okay, thank you.
Representative Tuttle.
Yeah, Mr. Chairman, I had a question of Director Wayne, if I could, about what other states are doing in this area. Is this something that's only an issue here in Maine, or are there other states dealing with similar issues? If I might ask that question, Mr. Chair.
Sure. You can definitely ask him, but that whole other states chart is attached to the bill analysis. So we did all of that research at OPA for you.
Yeah, Janet gave a full chart of basically every state. That was with her initial bill analysis that should answer a lot of those questions.
Well, Louie, I'm a lot older than you, so if she could refresh my memory, that would be helpful.
Yeah, well, we'll bring in Director Wayne as well.
Okay.
I'm trying to, there he is. Yeah, okay. And this is like one of those issues as you try to work through it, it just seems to get, obviously more and more complicated as it goes. So we'll bring in Director Wayne if he's there. And if I think the email from Janet, or maybe it's available on the actually it is available on the website under the bill, and we can send that over too, so you can see that chart of every state. So welcome, Director Wayne. I'm not sure if you heard the question from Representative Tuttle, if you're familiar with other states' laws in this area.
I did hear the question, and I need to defer to your very able analyst because I was aware that she had done some research in this area and I didn't see the need to. So I know some states do have relevant laws to this, but I haven't looked at them personally myself. So Representative Tuttle, I'm sorry, I don't have an answer for you.
Okay, I'm used to that, John.
Okay, thank you.
Yeah, so we've got that chart, and also the testimony from people talked about, I think Seattle was an example of one where they've gone more modeled on 497, I believe the number. Representative Bailey's bill. I think it uses some of those.
I
Yep.
I did have a briefer summary than the whole chart in the bill analysis of the other states. If you want me to just go through that briefer summary.
Sure, if you don't mind. Yeah,
I don't mind.
thanks.
I want to make sure people have the information they want.
Yeah, and you all spent a ton of time putting this together, so it's definitely good to review it.
So the way that the question was posed at the hearing is slightly different than the way you posed it, Representative Tuttle. So it's maybe not as organized as you'd want, but there was a question at the hearing about states that have referendum elections. How many of them have this type of prohibition? So there are 25 other states than Maine that have authority for their citizens to propose legislation through direct initiatives or popular referendum. Of those 25 other states, 12 of them limit foreign interference in elections to some degree. Of those 12, 3 of them only prohibit foreign national contributions to candidate elections. So that's similar to federal law. 2 of them prohibit only foreign national contributions to referendum elections. I can't say whether that's because they don't want to prohibit it to candidates or whether they feel like the federal law is sufficient on that point. And then 7 of the other states, of those referendum states, prohibit foreign nationals from contributing to both candidate and referendum elections to some degree. And then there were 5 other states that don't allow their citizens to propose referendums that do have foreign national prohibitions as far as candidate campaigns. And yeah, okay, sorry. And then if you look at all of the states combined that have any kind of prohibition on foreign interference in elections, 6 of them expressly adopt the federal definition of foreign national. 4 of them don't expressly adopt it, so they don't say we're following federal law, but the way that they wrote their definitions, they clearly did follow federal law because it's the same. And then 2 of them, 2 states, have definitions that look like they're more expansive than the federal law. So first there's Alaska, and Alaska defines what it calls a foreign influence corporation, and it includes domestic entities where a single foreign owner holds 5% of the equity or voting shares, or a group of foreign owners holds 20% of the equity or voting shares. This is very similar, although less expansive, but similar to Representative Bailey's proposal in LD 479. Unfortunately, if you like that broader definition, there is a provision of Alaska's statute, a different provision that states that the law's prohibitions against a foreign influence corporation's contributions and expenditures apply only to the extent that federal law prohibits those contributions or expenditures. And when addressing a different issue, Alaska's Attorney General issued an opinion, and if you read it, it suggests that as far as the Attorney General at the time that that opinion was written, as far as he understood it, this 5% and 20% of the equity wasn't legally effective because of the other provision of the Alaska law that says it's only a prohibition to the same degree as federal law. So I think Alaska falls into this 6 and 4, so it'd make 11 states that apply the same definition as federal law does for who a foreign national is. California's prohibition is similar to what Senator Lucchini's proposal is, as far as Representative Chiazzo's question was, because California's prohibition applies to domestic subsidiaries of foreign corporations if the decision to make the contribution or expenditure is made by a non-US citizen and non-permanent resident officer of the foreign parent corporation. And as I mentioned, that's similar to the Federal Election Commission's interpretation of the federal prohibition. Then there are 3 states that have a narrower definition of foreign national than the federal law because they only prohibit contributions and expenditures from a foreign corporation that's not authorized to conduct business in the state. And maybe that's something similar to what Senator Farron was suggesting, I'm not sure. One state's prohibition applies to the undefined term foreign national or foreign government instrumentality or agent, but it doesn't define those terms, so I'm not entirely sure what they meant. And then one state, South Dakota, only prohibits contributions or expenditures intended to influence campaigns by a foreign government only. And if we look down here, I thought that I had a link. I'm just looking. Maybe not. I thought I had a link to the FEC website. So I will send that to you, which explains why the Federal Elections Commission has, oh, here it is. It's up here. So this is the website I was talking about. They have a whole explanation of foreign nationals, and the FEC interprets the federal definition to include when the foreign owner or foreign parent of the subsidiary finances any of the contributions or expenditures, or if they're making the decisions. So that's how the FEC interprets current federal law.
Well, Karen, there was a reference to New Hampshire back a little bit. I wanted to look at that. Our wonderful neighbor.
Janet.
Yeah.
So it adopts the definition of foreign national, and I can actually show you New Hampshire itself. So the chart we were talking about, hopefully, I don't know why they're posted with weird names under 194. I'm gonna look here. So this other states chart, I don't know if you can search the text here. I'm gonna try. Here we go. So in New Hampshire, they have prohibitions both for candidate and referendum elections.
Right.
And it says that no expenditure or use of a contribution, tangible or intangible, shall be made for the purpose of promoting the success or defeat of any political party, measure, that would be your ballot measure, or candidate. And those expenditures or contributions can't be made by any foreign national for any purpose, including for the use of telephones, fax machines, vehicles, and computers, or for electioneering. And they specifically adopted the federal definition of foreign national when they made that law.
Do we know what year that was adopted?
I don't off the top of my head. I don't know if this link will tell us. Ah, yes, effective May 25th, 2018.
Okay. All right, well, I promise not to ask any more questions, Mr. Chair, for 2 minutes.
No, that's good.
Start your clock, Representative Chiazzo.
Yeah. Janet has given us an incredible amount of information on this. Representative Chiazzo, did you? Oh,
Yeah, thank you, Mr. Chair. So when you were going through the ownership again and the definitions, Janet, for Representative Tuttle, question popped in. How do you determine the percentage of ownership for privately held corporations that don't necessarily have publicly traded shares?
I do not know how you do that because I stay as far away from corporate law as feasible for my job. But I will say that I think that's what Senator Lucchini's amendment is attempting to get at, based on the suggestions in the testimony of having the CEO or the highest ranking official, if it's not a corporation, so it doesn't have a CEO, say that they've done due diligence and they believe that as of the date they made the contribution or expenditure, that they didn't have the percentage ownership that would put them into the foreign national category. And under Senator Lucchini's amendment, that's only 10% government owned. And where it's government ownership, I don't know if that information is available some other way, because it's the government that owns it as opposed to just some private wealthy family.
Right,
Yeah,
and I'm just
so
wondering.
yeah.
So sorry, go ahead, sir.
Oh, no, go for it.
Well, no, I was just wondering. I mean, you know, the governance of a privately held company is probably a lot. It can be a lot different than the governance of a publicly traded company. So just because you have a shareholder, it doesn't mean that they have voting interests. So if you have family members, let's say one happens to live in St. Kitts, but they're getting revenue or they're getting profit from the company, they might be on the board of directors, but that board may not have oversight over the CEO. So I'm just curious to know. It sounds like once you open that Pandora's box, it sounds like it becomes very, very difficult to make those determinations. And I appreciate the intent of the affidavit, but I think that it's getting a little it starts to get a little unruly, I guess, in my mind. So if it's not spelled out in statute specifically how to do it, I'm not sure if just the affidavit is enough to allay my concerns about that. But I understand the intent behind it. So sorry, Senator, I don't know if you wanted to elaborate on that intent.
Yeah, no, I think Janet summed up my amendment well. If you have, I mean, and the numbers obviously are flexible, but if the CEO can make an affirmation or highest ranking official, as it says under federal law, that, as written, it's either X percentage, so 10% of equity shares or voting shares. So that applies to corporate and private companies as written.
I just want to clarify, I may have misled you based on what you just said, Senator Lucchini. That is not current federal law. The certificate, that is proposed federal law. Right now, that's not addressed in the federal law.
Yeah, no. I didn't mean to say that was federal law. I meant using the term highest ranking official is from federal law, and we use CEO in the bills that were proposed, right? Is that right? Yeah. So CEO is in 194 and 497 or whichever, but in federal law,
it's in 479, and it was in Ron Fine's testimony on those bills. And the pending federal legislation says CEO or highest ranking official. And that was something that had been brought up earlier, that not every company has a CEO.
Yeah, sorry.
I thought you wanted to include it in your proposal.
No, definitely. Yeah, that was the part I was referencing on federal law using that term, but that is the part where we go beyond federal law for sure. On the ownership stuff.
Do you want to go back to the amendment?
We can hit the last, I think we're on the last column. Yeah, sure. Yeah, which is basically penalties, I think.
And just a reminder, in case we've totally confused everyone in this discussion, the only foreign company ownership proposal is if a government owns at least 10% of the equity or voting shares. Although, to be fair, I think Representative Chiazzo is worried about this provision of controlling the decision-making. Just trying to be fair to everyone to summarize where we are. Okay, so we were talking about the disclosure requirement. As an example for that, if a foreign national took out an ad in a newspaper saying, let me think of something that's a public policy issue. Maine should support lobstermen forever as a public policy, not necessarily tied to a ballot question or any specific candidate election that's going on. It might say Maine should support Representative Tuttle's bill. That's not a ballot question, and it's not saying support Representative Tuttle, but just his bill that you heard earlier. Then that would be a communication by a foreign national to influence government policy or foreign relations. And that would be the type of communication where the foreign national sponsorship of that communication would have to be disclosed. And then the final provision are the penalties. So Senator Lucchini is proposing that the Ethics Commission would have the authority to impose a civil penalty of up to $5,000 or the amount of the contribution or expenditure involved in the violation, whichever is greater. If you adopt that penalty, it will be placed in chapter 14 of Title 21A. There is a default provision in there already that says civil penalties in that chapter can be doubled if the violation occurs within 28 days of an election, and tripled if the violation occurs within 14 days before the election. And Senator Lucchini did not want to make that inapplicable. So this, which already exists, would apply. Just as a note, that penalty doesn't apply to the CEO, highest ranking official who makes that sworn statement, because that has the separate false statement penalty or false swearing under Maine law. Senator Lucchini indicated to me that he wanted this base penalty of $5,000 to the amount of the contribution or expenditure, because that is the same penalty under federal law for prohibiting violating the prohibition on foreign nationals influencing candidate elections. Under foreign law, they don't have this default doubling or tripling based on the time close to the election, but there is a doubling available if it's a willful violation. So doubling does exist, but maybe for different reasons under foreign law.
Great. Thank you, Janet. Representative McCreight.
Thank you, Mr. Chair. Janet, in this the penalty panel,
yep,
under the note. So what it's saying, I guess, is the CEO has made the attestation, whatever the word is. But unless it's the CEO who directly makes the statement, they're not held accountable. It's the person who makes the statement.
Let me make that clearer, because I definitely confused you, and I'm sorry about that. let's say the Ethics Commission gets a complaint that a company with 20% foreign government ownership made a donation a contribution to influence a referendum. So there's a couple of things going on there. There's the actual contribution itself that may have violated the prohibition on influencing a referendum if you qualify as a foreign national and the Ethics Commission investigates and sure enough it's 20% owned, this company, by a foreign government. Yes, violation has occurred. The corporation itself, which made that prohibited contribution, would be subject to this $5,000 penalty maximum or maximum amount of the contribution. So if it was a $100 contribution, then they could be penalized up to $5,000. If it was a $50,000 contribution, they could penalize up to $50,000. So that penalty would go on the corporation itself. As far as the fact that this corporation was in fact a foreign national because it had this 10% or more ownership by the foreign government, the CEO should have made a certification when it gave the contribution to the ballot question committee or the political action committee, whoever was running the campaign. And sure enough, the Ethics Commission looks, and yes, the CEO did make that certification and they weren't telling the truth, then that CEO or highest ranking official can be prosecuted for false swearing. So that's a separate prosecution. It's a criminal prosecution. It wouldn't be done by the Ethics Commission. They'd refer it out. And if they were found guilty, it's a higher standard because it's criminal law, then they could have an up to $2,000 fine for that individual who made the statement or imprisonment of less than a year. Did that help?
Oh, sorry.
Can we go back to the last panel? Okay, yes, got it. Thank you.
So yeah, and I can try to clarify too, because when it comes to that foreign ownership within a corporation, the only way that we could verify it is through the CEO, that CEO thing. And in some of the testimony, I think on 479, it had recommended like a sworn statement and potentially perjury if you violated it, which was a more serious crime. But I, for this purpose, just went with breaking the law for the false swearing on a government document. It's kind of where that came up. I didn't want to make it super strong, if that helps. Representative Chiazzo.
Thank you, Mr. Chair. Janet, I don't know if this is the right way to word this or not, but in determining so let's say a CEO files an affidavit, they make a contribution, somebody refutes that. Okay, the opposing group refutes that. They lodge a complaint with the Ethics Commission. Okay, is the burden of proof to determine ownership on the company to prove that they're not foreign owned, or is it on the Ethics Commission to prove that they are foreign owned?
This would be a regular Ethics Commission proceeding because the Ethics Commission can proceed as far as the contribution being legal or not. They wouldn't necessarily be proceeding with the criminal part as far as the CEO. And for that, I'm going to defer to Director Wayne because he knows where the burdens are in those proceedings.
Yeah, I think he's still in here. If you're here, Director Wayne. Oh, there we go. So can you walk us through, Director, how that would work?
Yeah, I mean, I think initially the person filing the complaint would have some sort of burden, which is typical in our campaign finance enforcement measures, to sort of show that a violation may have occurred. If we're doing the investigation, usually then, if somebody has made that showing to us, it goes to our commissioners. I mean, that's a determination by our commissioners at a public meeting, and then they would direct us to conduct the investigation. And then we would ask for corporate ownership record. If we were doing the investigation, we felt that was our duty as opposed to the AG's, we would ask for corporate ownership documents from the contributor or the spender and to try to sort it out to our satisfaction. Alternatively, this is, if this is more of a criminal penalty rather than something we would punish for, we might just refer it to the AG's office. So we'd have to think that through.
And Director Wayne, I would assume that it could possibly be a parallel path, correct?
Where we look into it and the AG looks into it? Yes, that's definitely possible. Yep.
Great. And I guess, Director, while we have you here, one of the reasons why I support the foreign national portion, at least on this, was that, a few years ago, we had a big ethics investigation around the York County casino referendum, where it appeared that money was coming from the US, but then we later found out that there was, foreign nationals sending money into to influence that referendum, millions of dollars. And, because it was improperly filed, they were subject to an ethics complaint and violation. And I think the recommendation was from the Ethics Commission to fine them like $500,000. However, because they're foreign nationals in our jurisdiction, it's difficult to actually get that money. We had to settle for a sum that was far, far less. Can you speak to like the difficulty of getting money from foreign nationals? So essentially, in my view, they don't get to play by the same rules as Maine residents because they can't really get hit with those financial penalties.
Yes, that's right. In that casino investigation, initially the funding for the casino initiative and the petitioning process was presented to the public as being from Lisa Scott, who was the sister of the casino developer. And then after a complaint was filed and we did an investigation, we determined that the reporting was incomplete and inaccurate, and really the true sources of the money were from out of state. Out of the continental U.S. Some of the donors were from Asia. Some of the donors were from the Northern Mariana Islands, which is a U.S. territory, but was still. So anyway, if you're trying to collect, there can be huge obstacles to trying to collect a penalty if it's not paid voluntarily from a foreign entity. And so the advice we got from the AG's office was, after our commissioners assessed a penalty of $500,000 total, that it was very difficult to collect. So we ended up settling for 1/5 of that amount, which was $100,000. So yeah, foreign, collecting against a foreign entity, that's the bottom line, can be very tough.
Right, and even from that 100,000, only a portion of that was paid by the foreign national as well, because it also involved Maine residents who obviously have to follow the law more than the others, the outside. I don't know if that was.
That's correct. One of the persons penalized was local and working on behalf of the foreign funders, and so that person was caught up in the penalties as well. But we thought it would be unfair to only seek to collect from the local person.
Yeah. Representative Chiazzo.
Thank you, Mr. Chair. And this is somewhat germane, I think, to the conversation. But if the intent of this bill is to allow for collections or prohibit the possibility of having to collect from foreign nationals, I know in the international business community, when you're dealing with multiple jurisdictions and laws and overlapping and ordinances and things like that, they have security bonds or something that's basically a good faith security mechanism. Is that something that could be explored? If you have a group that wants to lobby or put something, you don't have to put the money up front. Oftentimes it's a separate agreement, but it is there with specific instructions or limitations of when it can be accessed, how it can be accessed, things like that.
Well, I think it would all depend on the details, Representative, in terms of who would have to put up the bond and under what circumstances. I think I'd want to have a conversation with the Attorney General's office about that. And we don't want to make it too hard. Part of the problem here is we don't know. We don't want to assume that all contributors are potentially foreign owned. We don't want to pile up the bureaucratic or administrative burdens on all contributors. Most of them are not foreign owned. So that was why I, for example, reacted to Senator Lucchini about asking almost every contributor to file a certification. That just seemed too broad, too widespread to me. So I think it would have to be done just right and under the right trigger or circumstances? What's the predicate for requiring someone to put up money just because they're a contributor? That would have to be thought through. Yep.
Follow up, Sam? Thank you. Yeah, I'm wondering if we go a different tact and require, I think it was 2 of the states that required them to be state registered foreign entities or state approved entities. If we did something along that route, if that would be a security mechanism that we could use as an enforcement feature or not.
Sorry. So who would be registering with us? When would they? What would be the trigger for them to have to register with us?
From Janet's presentation, and correct me if I'm wrong, Janet, I think it was there are a couple of states that actually allow for foreign entities to register within the state, and only those approved. So if I'm wrong, Janet, jump in. I'm sorry.
Let me try and help and see if I can understand. So in those 2 states, you can't be a foreign national under the federal definition, which are those, individuals, and then wholly owned or foreign organized entities. Those are clear. You can figure out who they are. Mm-hmm. And then also in those states, if you are any other foreign owned entity that doesn't have the authority to conduct business in the state, actually, excuse me, let me back up. So in those states, you can't be a foreign government, a foreign political party. You can't be an individual who's not a citizen, et cetera, and so forth. And then the only businesses that can't contribute to elections in those 2 states are businesses that don't have authority to conduct business in the state. So it's everybody else. Those would be the ones that we would have the most jurisdiction over. So those are the ones that you wouldn't need to enforce a fine against because they're allowed to make the donation. Does that make sense?
I think so.
I think it's kind of backwards.
Yeah, what I'm trying to get to is that we clearly have corporations or companies that are Maine based that have probably a significant amount of foreign ownership, and I'm trying to not exclude them from the process of being able to have political speech like everybody else. So I'm wondering if I feel like this amendment, this bill as proposed, is very far-reaching and very limiting, and penalizes those groups. I'm wondering if there's a way we can try and thread that needle to obviously prevent foreign government intervention, foreign national intervention, but find a way to carve out something that allows those companies that we've asked to come and do business here still be able to participate in the process somehow. So I'm wondering if the concern is the enforcement piece of that, because they're foreign entities or foreign registered and we can't recoup any potential damages to them. I'm wondering if there is a process where we could have them register in the state, even if they are predominantly foreign invested, and have another mechanism in place specifically for that group to help alleviate our concerns, where if there is any impropriety, we have recourse and we're not basically having people kind of skirt the laws unnecessarily. I know it's totally overcomplicating an already very complex issue. I'm really just trying to thread that needle somewhere to try and preserve and protect the entities that exist now and have them, maybe for lack of a better word, a grandfathered mechanism for them at least, or some mechanism moving forward that helps protect those groups. That's all.
Yeah, I think to Janet's point, states will clearly exempt those that are registered, a few states that are registered to do business in their state to allow them, if that's what you're into, I think, yeah. And then if we wanted to add a layer of enforcement, I'm not sure how we'd structure that, but perhaps Director Wayne and the AG's office can think of something, because that, I see what you're saying. And I think other states, they have that kind of expressly built in, that a corporation registered to do business is the exception in your state. I think to Janet's chart that showed that. And so Director Wayne, to the issue we kind of brought up about, a threshold before the corporations would have to contribute, that would prevent the situation where every single nonprofit who wants to donate to a ballot question would have to do a filing with the Ethics Commission where under current practice, they don't have to do any filing unless they cross over into that major contributor section of $100,000.
Right. I mean, in most states and most campaign finance systems that I'm aware of, contributors are free to give money to a PAC or BQC, and that's how they choose to influence an election, and they don't have to get too entangled with the state government in order to be involved to that limited extent. And so to require someone to file this kind of certification, I suggested a monetary threshold to the senator because I don't want to influence the discussion too much. It just seemed burdensome to ask all sorts of contributors, no matter how little they're giving, no matter how remote the chances are of foreign ownership, to all have to make this kind of certification. So I proposed $100,000. We do have a major contributor report that maybe it would make sense to fold this into that report because they're already filing a report with our office, so they could make an additional certification as part of the report. Or if you wanted to leave it as a separate certification, we could explore that too.
Right. Yeah, no, I appreciate you flagging that for me because that was one of those unintended consequences, I think, from both pieces was that if you're trying to get at those corporations, then you have to have everybody file that certification, which seems way overly burdensome for what I think the intention of what people are trying to get at. And so once you get into that $100,000 level, you're filing stuff anyway with the Ethics Commission. So it wouldn't be really a burden at that level to add, in my view. So I'm glad you flagged that because it would have been, I think, a big problem for a lot of people, or just a lot more work. It wouldn't, it'd be potentially a hurdle to people contributing to something that's important to them. Representative Tuttle.
So, Mr. Chair, where are we going from here?
Well, I think we just wanted to give people a chance today to ask questions and get more information on this. I know it's a super complicated topic, and there are a few different variations of the bill that we're looking at. So
we need more time, Mr. Chair. Is that your feeling?
I mean, I think so. I don't think we're probably in a position to vote at the moment, but
okay.
I think trying to fine tune a lot of the stuff will probably, it's a little bit of tedious in some of the details.
So the motion would be in order to table 194 and 479?
Are you making that motion, Representative Tuttle?
I am, Mr. Chair.
Okay, so Representative Tuttle has made a motion to table.
I'll let you in a few minutes.
194 and 479. That motion is not debatable. So
we need a second.
Oh yeah, sorry. Is there a second on that motion?
I'll second that motion.
Okay, so the motion was by Representative Tuttle and seconded by Representative Supika. And we'll proceed to a vote. We can't discuss it, Representative, unless you had a point of order question, Representative Corey.
No, I was just voting.
Oh, sorry. Gotcha. Okay, so we'll, Karen, if you're ready, can you please call the roll?
Point of order, am I calling for both votes at the same time, correct?
Yeah, I think Representative Tuttle made it on both. Is that correct, Representative Tuttle? Yep.
Yes, Mr. Chair.
Yep, thank you.
Senator Lucchini?
Yes.
Senator Lucchini, yes. Senator Hickman? Senator Hickman, absent. Senator Farren?
Yes and yes.
Thank you, Senator Farren. Senator Farren, yes. Representative Chiazzo?
Yeah and da.
Representative Chiazzo, yeah. Representative McCray?
Yes.
Representative McCray, yes. Representative Tuttle?
Yes.
Representative Tuttle, yes. Representative Riley?
Yes.
Representative Riley, yes. Representative Supika?
Yes.
Representative Supika, yes. Representative Wood?
Yes.
Representative Wood, yes. Representative Kinney?
Yes.
Representative Kinney, yes. Representative Harrington. Representative Harrington, absent. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolliff.
Yes.
Representative Dolliff, yes. Eleven in favor of the motion, 0 against the motion, and 2 members absent, Mr. Chair.
Great, thank you, Karen. So it's unanimous of those present, and if people have more questions, I know we can put out information requests with Director Wayne or any of the people, the sponsors, anybody who may have more information. So with that, I'll turn it over to Chairman Chiazzo for the next bill, I think. LD 670, is that right?
Yeah, we can do 670 next, sure. Thank you, Senator Lucchini. 670 was, let's see, that was for the, bear with me for a second, please. 670 was.
I can take over.
Yeah, go for it, Janet. You run. You have the con.
LD 670 is an act to increase the lobbyist registration fee. Just a second. Let me call it up. We've already had one work session on this bill. Just to remind you. Oh, wrong bill.
That was my problem earlier.
Here we go. This is the bill that talks about the lobbyist registration fee. So current law requires each lobbyist to register annually with the commission no later than 15 days after lobbying more than 8 hours in a calendar month for a single client, which is called an employer under the lobbyist laws. When the registration is filed, the lobbyist pays a $200 registration fee and an additional $100 for each lobbyist associate that works with the lobbyist for that employer/client. So the bill would increase the registration fee to $250 per employer, and for each lobbyist associate working for the lobbyist and for that same client/employer, it would go from $100 to $125. At the last work session, there was a question whether there might be a need for a hardship waiver for certain lower income or nonprofit type clients or employers of the lobbyist, because they would pass that registration fee on to their client, of course. And there was a suggestion that Director Wayne might be willing to work on drafting language to that effect. And I believe that may have happened, and that Representative Supika might be willing to propose an amendment. Normally I wouldn't reveal that, but she already authorized me to send it to you, so I don't feel like I'm disclosing confidential information.
Yeah.
Okay.
No,
hold on a second, Representative Speaker. Representative Kinney, did you have a question? I'm sorry.
Yeah, it's just a point of order. I think when we have bills on the table, even though they're scheduled for work session again, I believe we need to vote to take them back off the table to continue on with the work session.
Okay, then we will entertain a motion if that's so in order.
So move, Mr. Chair.
Hold on, Representative McCray.
I was just going to move that we take LD 670 off the table and continue to work on it.
Thank you, Representative. So moved by Representative
I'd
McCray
be happy to second.
and seconded by Representative Kennedy. Thank you. I think we could probably do that by a show of hands. So if you want to, everybody hands who support taking LD 670 off the table. So I have 1, 2, 3, 4, 5, 6. Senator Farron, 7. Representative Riley, 8, 9, 10. Karen, I have 10 and 0. 10 for, none again. Any opposed to taking it off the table? None? Okay. So the motion to take LD 670 off the table passes. Thank you, Representative Kinney, for that point of order. I appreciate the guidance as I get used to this stuff. So LD 670 is back on the table again, and I think we were at Representative Supika. If you wanted to go through your your amendment?
Yeah, so the amendment just gives an opportunity for a lobbyist or an employer to go to the commission and ask for a waiver of fees, and then the commission has a system set up where they would examine that and make a determination. So they could grant it in whole or in part, and I think that this is a really good compromise, especially in light of the pandemic, of any, maybe business is down, or this is a good step in the right direction for a compromise to I think pass this, so that we're not being too harsh after the past year that we just had. Is that the kind of explanation I was supposed to give? This is my first amendment, and I really took the lead from thank you, Representative Corey here, because he kind of presented the idea and was more knowledgeable on the subject, and the fact that the commission or the ethics was very supportive of this, so I feel good about the amendment.
Do you want me to show the language?
Huh?
Do you want me to show the language?
Yeah, I mean, am I supposed to show the language? I mean, we could show the language of everybody. I don't know how I would do that, so. I'm
happy to. It's up to you all.
Yeah, if you wanted, I think Janet can share her screen a lot easier than we probably could. So, if the committee's interested in looking at the language, for sure.
So this is the proposal. It was drafted by the Ethics Commission staff and sponsored by Representative Supika. So the first paragraph here is what's already in the bill. It's just that the Ethics Commission proposes we break this section of law into 2 subsections to make everything easier to follow. So the changes, excuse me, to the registration fee amount would stay, going from 200 to 250 and from 100 to 125. Excuse me. But now there would be a waiver of fees due to hardship. So the lobbyist or the employer, which again is the word for client in this portion of the law, if they believe that the payment of the fee would constitute an economic hardship, they can apply for a waiver from the commission. The commission can set forth or establish the application form and can request any information it views as relevant, including but not limited to the amount of compensation expected to be paid for lobbying, overall budgeted expenses for the employer, or revenue or expenses in the prior year. And then the commission would have the discretion to grant the application in whole or in part. So this was all the proposal from the Ethics Commission and supported by Representative Supika.
Okay, any question, Representative Tuttle? Representative Tuttle, you had a question, sir?
Well, no, Mr. Chair, if it's in order, I would move ought to pass as amended.
Okay, we can entertain that motion now. Do we have a second?
I'll second it.
Seconded by Representative Corey. Okay, so move ought to pass as amended by Representative Tuttle, seconded by Representative Corey. Discussion. Representative Corey.
Thank you, Mr. Chair. Yeah, I'd just like to thank the Ethics Commission for standing up and creating that amendment for us. I think that when Representative Supika and I got it via email, I mean, it was perfect. It required very little discussion going back and forth. This makes it a lot more comfortable for me to support with that jump in price. So I'm good with this, and I'll happily vote for it.
Thank you, Representative Corey. Any other discussion or questions or comments?
What a team.
All right, seeing none, the motion on the floor is ought to pass as amended. Karen, we can take the roll when you're ready, please.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman. Senator Hickman, absent. Senator Farren. Senator Farren, we can come back to him. Absent. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington. Representative Harrington, absent. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolph.
Yes.
Representative Dolph, yes. Senator Farren.
Yes.
Thank you, Senator Farren. Senator Farren, yes. 11 in favor of the motion, 0 against the motion, and 2 members absent, Mr. Chair.
Thank you, Karen. So the motion ought to pass as amended is successful. Those absentees will have 2 days to register their votes with the clerk. And I will turn the proceedings back over to Senator Lucchini.
Thank you, Chairman Chiazzo. So I guess next on our list, we have LD 1126. Senator Farren.
Yeah, Senator, I just, while you were gone, and I just from a standpoint of, I'll show a rookie, even though this is my 4th term, right? If we have, Representative Kinney brought up the fact that we had a bill that was tabled from a previous one and that we had to have a vote to take it off the table and bring it back up again. Can we, I just want to make sure we're all on the same page. I know some committees, if it's advertised and we got it, we don't need to do that, and others do. And I just, either Janet or Karen or you or whatever else, I just want to make sure we're all on the same page so we're following the same rules.
Yeah, sure. Generally, if we advertise it, then I don't take a motion to take it off the table. But if it wasn't on the agenda, then I would make a motion. But if we advertise in advance, usually we just take it up as we go through. That's how I've always done it. Sorry, is there a question? Oh.
No,
okay.
Just so we're all on the same page. I don't know. Yeah. I see Mary Ann shaking her head. I don't know if she's talking to us or not.
Well, kind of. I also am in my 4th term, and previous committees, we've always, if it was previously tabled, we did have to remove it from the table. But I have asked for some clarifying information on that, on how we're supposed to proceed. I'm just going by what I've always done in the past in my previous committees.
Yeah, I think a lot of committees do things differently, and we can double check with the clerk and the secretary.
Just keep us all out of trouble.
Yeah, blame it on them.
Well, that's what I was trying to do, was keep us out of trouble by taking it off the table first.
That's good. Representative Corey.
Yeah, I'm going to agree that every committee does things differently, even in appropriations when we're voting in items into a budget and everything. We're just doing it by the thumbs up and everything. So not everything is even getting a roll call. And, I've been seen other committees on tabling motions just do hands up and we're all good. So I think it changes from committee to committee, especially in this digital age. So.
Yeah, and I think a lot of it, the chairs have discretion to do whichever process works. That's good. As long as it's advertised, I think generally that way the public knows is the important thing for us.
Well, everybody expects you to do it perfectly, Louis. So.
Yeah, no, they really love the time clock. There it is. Yeah. All right. So I guess we can, I forgot, what do we have? 1126? From Monday. I think, Janet, we haven't done this one yet, have we?
No.
Right. Okay.
For some reason, I can't find that screen. What is going on?
It's okay. We can take a minute.
It is not helping me. Sorry. Try again. There we go. Too many windows open.
There we go. Nice.
So LD 1126 is an act to update the voter registration process. This is Representative Persis' bill. It requires the Secretary of State to implement a process for accepting online voter registration applications through the Secretary of State's publicly accessible website beginning January 1st, 2023. That's the date in the bill. As far as a summary, although it doesn't look very summarized because it's long, under Section A10 of the bill, an individual submitting an online voter registration application must disclose and attest to the truth of the following information: their legal name, including at least their first and last name, or first initial and middle name and last name, date of birth, current residence address and mailing address. If they were registered before, the most recent address at which they were registered, and also the name under which they were registered in case it was different from their current name. For example, if they moved when they got married and changed their name. They would also have to include either of the following: either their current valid Maine driver's license or non-driver ID card number. And if they decide to go that route, they have to be informed that disclosure of this number constitutes consent to use of their signature on that driver's license or non-driver ID card for all voting purposes. For whatever purpose you would have on your voter registration application signature, the same purposes could be used with your signature on your driver's license or non-driver ID card. If they don't disclose that number, they have the other option of disclosing the last 4 digits of their social security number. If they select this option, the applicant must also submit an electronic image of their signature with their online application. In addition, the online application would have to include 2 questions required by the Federal Help America Vote Act, which is HAVA sometimes referred to. And the questions are you a citizen of the United States of America? And will you be 18 years of age on or before Election Day? In addition, the application would have to have a space for the applicant to indicate whether they want to enroll in a party, and if so, which party, and if not, for them to indicate that they would like to remain unenrolled. Under the bill, the deadline for submitting the online voter registration application is by midnight the 21st day before the election. After that time, they can only register to vote in person. Under Section A2 of the bill, the Secretary of State's office must submit any received online voter registration applications to the appropriate registrar's office daily. And then following from the bill and the way current law is written, at least 18 days before the election, the registrar would be required to mail an acknowledgement notice, which is required in Section 122 of Title 21A, to the applicant by non-forwardable mail. If the notice is returned as undeliverable within 15 days after it's sent, the application should be rejected. If it's not returned as undeliverable, the application would be designated as active in the central voter registration system. The bill also directs the Secretary of State to permit registered voters to perform several other activities through the online voter registration application. So they would have to be able to change their name or address using the online system. Importantly, under current law, on Election Day, you can't change your name or address in your registration over online or by mail or any other way. You're supposed to do that in person, and that's not changed in the bill. So if you want to change that information on the day of the election, you have to do it when you go to the polls. The online system also would have to allow a person to enroll in a party if they're currently unenrolled, or to change their enrollment. So if they're currently enrolled in one party, the online system would have to allow them to change that enrollment. Or if you're enrolled in a party, the online system would have to allow you to withdraw your enrollment. And then all the prohibitions in current law about when you can enroll or unenroll or change your party, all of those existing prohibitions in current law and limitations would apply if you do it through the online system. The bill just says that you can do those actions online in addition to in person or by mail. The bill also has a section, which is A12 in the bill, directing the Secretary of State to adopt routine technical rules on a number of subjects, including requiring the online voter registration applicant to disclose their driver's license number or non-driver ID card number and consent to the use of the signature on that card for voting purposes, or to disclose the last 4 digits of the social security number and submit an electronic image of their signature. The rules also have to establish a process for verifying that the applicant's driver's license or non-driver ID card number and the applicant's name and date of birth on the online system match the information in the Bureau of Motor Vehicles database. And if a match is found, there has to be a process through rulemaking to transmit the electronic image of the applicant's signature to the central voter registration system. The rules also have to, under number 3 here, establish a process for matching the last 4 digits of an online applicant's social security number and their name and date of birth with the federal U.S. Social Security Administration's information associated with that social security number. The rules also have to establish a process for transmitting applications and electronic signatures to registrars of voters, establish procedures to ensure the accuracy and security of online voter applicants. I think that should say applications, I apologize. And establish processes for voters to change their names and addresses and change their party enrollment through the online voter registration application. The bill also has provisions requiring the Secretary of State to consider whether to adopt rules establishing a process for third-party organizations to submit online voter registration applications. And then there's a Part B to the bill, which would direct the Secretary of State to submit a report by June of next year to this committee on the feasibility and progress made toward implementing that third-party organization process for submitting applications. Just so you know, I think this third-party information was proposed to be eliminated by the sponsor, but we'll see when we get to that point. Some additional information. Voter registration requirements under current laws compared to the bill are shown in the first attachment to the bill analysis. And what you may also find helpful, because I believe there was a discussion, this might be a first work session, you might want to go to this link. It downloads a document, a Word document that shows the actual mail-in voter registration card, and it has instructions for each little piece of it. In addition, there's also an attachment to the bill analysis showing the information from other states. So I'm just going to scroll there to show you what's available. I won't go through those unless you want me to, but this first attachment compares in-person voter registration on in-person voter registration to voter registration by mail to the online voter registration that's proposed in the bill. It compares the deadline for these, the contents of the applications. You can see almost everything's the same. And it compares what proof of identity is required from these applicants and also the proof of residency required from these applicants. And I'm happy to go through that if you want. The second attachment, as I mentioned, is the NCSL information on other states and online voter registration. They have a summary that they wrote and then a list of all the other states with online voter registration. And you can actually click these hyperlinks that they made. Don't give me credit for that, they did it. And you can go and look at those online voter systems, voter registration systems, excuse me. So at the public hearing, the bill sponsor proposed amending the bill in a few ways. First, to correct throughout the bill some duplicative language. So that's a technical amendment where it says Secretary of State's publicly accessible website throughout the bill next to the phrase online voter registration application, but that phrase is defined to include the website, so it's very duplicative. So they suggest correcting that. I think that's a great, from a drafting standpoint, whether you like the bill or not, I think that's a great idea, a good fix. Also to clarify in section 812 of the bill that registered voters may update their names or addresses by using the online voter registration application. Right now, it just says they can update their names and addresses on the Secretary of State's website. So the sponsor says we need to make it clear that it's using that same application form, online form. The third item that the sponsor suggested amending was to remove the requirement that the Secretary of State adopt rules requiring the applicants online to disclose either their driver's license or non-driver ID number or the last 4 digits of their social security number. And instead of making that a rulemaking requirement, just put that requirement right in statute. The sponsor also proposed striking Part B, which requires the Secretary of State to do a study on the feasibility of allowing third-party organizations to collect and submit online voter registration applications. And the sponsor also proposed changing the effective date of the bill to November 1st, 2023. If you are interested in this sponsor amendment, I might ask, as far as this, striking Part B, requiring the Secretary of State to perform that study. whether the sponsor or you all, since this would now be your amendment, if you decided to vote for it, if you also want to remove the permissive rulemaking on this subject of third-party submissions, if you just want it to be the applicant submits their own online application and doesn't go through a third party. The Maine Municipal Association and the Maine Town and City Clerks Association at the public hearing requested that both in the bill as it's written and as it's implemented, that municipal clerks be ensured ready access to the voter's signature, because the clerk uses that signature to verify petition signatures and compare signatures on absentee ballot applications and return envelopes. The association also observed that the bill doesn't require registrars to print out and maintain paper files for online voter registration applications, but the association believes those are good backups to the electronic records in the central voter registration system. An individual, a Maine resident, and I never know whether you want me to name individuals that are in association, so I didn't hear. If you need me to, I will tell you who it is. I'll find their testimony, but I just wasn't sure, so I just put Maine resident. Submitted testimony expressing concerns about the security of online voter registration records, potential safety risks if address information is released to survivors of domestic violence, sexual assault, and stalking, potential breaches of the online data, which could be sold to companies for marketing purposes, and whether the online system will be truly accessible to Mainers with disabilities and Mainers who live in rural parts of the state without reliable internet access. There were several requests for information that I noted down during the hearing, and I hope I captured accurately what your questions were. I see there's a hand. Do you want me to stop and take that question now?
Sure. Representative McCray, do you have a question on that portion?
Yeah, just back up a little bit, Janet, the resident comment. I believe we have a system already for survivors of domestic violence to maintain their privacy of their records. Isn't that correct?
There is an address confidentiality program. I don't know exactly how the Secretary of State's office views that dovetailing with the online applications, but I would imagine that they would consider it. I can't imagine they would ignore it, but it's best to ask them, I think, directly.
Okay. Yeah, we can bring them in if you're good, Representative McCray, after Janet finishes up, and then we can, sure, thanks.
So the first question I wrote down was, how would the voter's signature be transmitted from their driver's license or non-driver ID to the municipality? And the Secretary of State's office, I just copied and pasted this answer from an email they sent to me, is that data captured in the online application would be transmitted directly to the central voter registration system, which would be linked on the back end with the Department of Secretary of State to the driver's license system. So that way the signature and all other voter information would be stored in the central voter registration system and accessible to municipal clerks in the same way they currently access all other data specific to their municipality in that central voter registration system. There was also a question about whether the Secretary of State would be considering adopting specific requirements for ensuring that the electronic image of the voter registration's applicant's signature is sufficiently high quality to be used by municipal clerks. And remember, the electronic image of the signature is only submitted by an applicant who doesn't have a driver's license or a non-driver ID card. And so they're submitting the last four numbers of their social security number. And the answer from the Secretary of State's office is yes, we think it's best developed in rulemaking based on the technology procurement for the system. If you recall, they are anticipating purchasing a new central voter registration system in the future. The Secretary of State's office recommends that the committee align any statutory requirements for the signature with the requirements for the automatic voter registration bill passed in the 129th legislature, which specifies that the signature of the applicant must be collected in a way that ensures the quality and integrity of the signature. And I just wanted to note to you, if you look in the bill, that is the language that is maintained in the bill. So what may not be clear to you when you look at the bill is section A10, which starts on page 3, which lists all the information that must be submitted with the online voter registration application, is actually the section of law that lists all the information that has to be supplied with any application for voter registration. It's just adding some information specific to the online application. So that whole signature quality and integrity is in the law and will stay there unless you amend it out. The next question was, how would a municipal clerk verify an electronic signature or verify the contents of the application? According to the Secretary of State's office, when entering a new paper record into the central voter registration system, where the main driver's license or ID number is provided, clerks can search the Bureau of Motor Vehicles data for verification that the voter name and address in that data match the voter registration system. However, the Secretary of State's office's intent is that the data will come from the Department of the Secretary of State with verification already done within the central voter registration system, communicating with the Bureau of Motor Vehicles system so the clerk knows it has been verified. So I believe what that means is the Secretary of State does not believe that the clerks are going to be verifying the online applications. They believe the system itself will be verifying it and communicating that verified status to the clerks. They will, of course, correct me if I'm wrong. The last question I had written down was, are you aware of best practices and procedures for online voter registration generally and electronic voter registration signature collection specifically employed in other states? They answered yes. They've been in contact with secretaries of state from around the country, including in Colorado, New Jersey, Michigan, and Vermont. They've linked a Brennan Center for Justice recommendations around signature collections, and that's the link here. So you can click there to get those recommendations. And the department is planning to work with other secretaries of state to leverage their knowledge and development of the system. There was also a question similarly about electronic images of voter signatures to Mr. Sedlak from the Maine Conservation Voters. I did want to note there's one technical issue with the way that the bill is drafted. And it's just a conforming amendment. So under current law, if you want to withdraw from a party, you have to do that in writing. And so the bill says that you can do that in writing or using the online system. But then there's a subsection 2 there that says that the voter can enroll in a different party for 15 days. And it refers to the written request, but that written should be crossed out if you do want the request to be made online as well, or else this limitation about enrolling in a new party won't apply equally to mail withdrawals as it would be applied to online withdrawals. And the fiscal impact is not yet determined. So I don't know, I'll take direction from you on whether to go through any comparisons of the chart or what to do next.
Great, thank you, Janet. So does your chart, sorry, I'm trying to pull it up next to this. It goes through the comparisons of online and current by mail.
Yes.
I think that'd be helpful to walk through if you're ready for that.
Okay, it's a little weird. I've never done this before where I like have half the bill analysis in portrait form and half in sideways form. I know that's not the official word, but that's the only word I can think of now. I was very proud of myself for this. So please all clap for me in your heads, not out loud. I was so proud of myself. This is the kind of nerdy thing I do. Okay, so as far as the deadline for registering, if you register in person, you can do that up and until election day. If you register by mail, you have to do that by the close of business 21 days before the election. And under the bill, if you register online, it's until midnight, 21 days before the election. This 21-day period, just as an aside, is because there has to be time for the clerk to mail the written acknowledgement form to your address by non-forwardable mail to see if in fact you do live there. If that form is returned, then if it's returned as undeliverable, then they don't accept the registration in the system. You can still show up and try and vote, and then they'll either get your proof of residency at that point, or they'll require you to cast a challenge ballot because you haven't proved you lived where you say you lived. As far as the contents of the application, in person, by mail, and online are all the same. In the first couple of categories, you need your name, residence address, mailing address, date of birth, and your most recent voter registration address, if any, and the name you use to register there. If you vote in if you apply to register in person, you need your signature. And beginning on January 22nd, 2022, that must be collected in a way that ensures the quality and integrity of the signature. This is the language that was added through automatic voter registration. It's not effective now because automatic voter registration, which is where you automatically are registered at the Bureau of Motor Vehicles unless you opt out, that isn't effective yet. So this language isn't effective yet, but it would be effective before the effective date of the online system. So all across the board, in person, by mail, or online, you would need to have your signature collected in a way that ensures its quality and integrity. All three systems, you have the option of choosing a party or unenrolled status. If you apply in person, you have to give your driver's license or non-driver ID number. Or if you don't have one of those, the last 4 digits of your social security number. Or if you don't have that either, you can say none. That's the same. If you submit your application via the mail, you would just write none in the questions here. But it's more limited with the online system proposed in the bill. You would have to have a driver's license or non-driver ID number, or you'd have to submit the last 4 digits of your social security number. The bill contemplates that if you don't have either of those, you cannot register to vote online. So it's a little more restrictive as far as the bill is presenting online voter registration. The questions from the federal HAVA law about whether you're a citizen of the United States or if you're going to be 18 years of age on or before election day, those are asked in person, by mail, and online, all the same. Requiring the applicant to attest to the truth of the information provided in the application is the same in person, by mail, and online. So as far as proving your identity, I hope I don't make it too small if I zoom out because this broke across the page and you can't see it all if I don't do it otherwise. So your options to prove identity, remember this first column's in person. If you're in person before the Register of Voters, municipal clerk, and you're registering to vote, you have to show a government issued photo ID, or the clerk could rely on a government issued non-photo ID, for example, a birth certificate or social security card. You could instead show an official document showing the name and address of the voter, for example, a government document or check, utility bill, bank statement, paycheck, for example. Or you could show your driver's license or non-photo ID number, or the last 4 digits of your social security number verified through the central voter registration system. So all of those are ways that current law contemplates that if you're registering to vote in person, then you could prove your identity. If you register to vote by mail, federal law specifically requires that a person who registers by mail for the first time in the state has to submit a current valid photo ID, or a current utility bill, bank statement, or government check or paycheck, or government document that shows the name and address of the voter, or the person's driver's license or non-photo ID number or last 4 digits of their social security number verified through the central voter registration system. You'll see this federal law, very similar to our state law about how you prove the identity. I would guess, I wasn't here at the time, we sort of modeled this state law on identity on the federal law, but I can't guarantee it because I wasn't here then. Under federal law, however, if you register to vote by mail, if your proof of identity is not included, so you don't have a copy of one of those things included with your application, and you go to register and you go to actually vote, you have to present either the current valid photo ID or current utility bill, bank statement, etc., and so forth, showing the name and address that you have. When you go to vote for the first time, if you don't bring one of those documents with you, then you have to vote with a challenged ballot. And the Department of Justice has frequently asked questions about this whole HAVA and the motor voter law and everything else on their website. And if you do follow that link, this is question number 11, if you wanted to read their explanation of this requirement. As far as online voter registration, however, the bill, as far as proving your identity, requires that you provide a driver's license or non-photo ID number and the last 4 digits of your social security number, and those would have to be verified through the central voter registration system, either against the driver's license database or against the US Social Security Administration database. And those are the only two ways to prove your identity under this bill's version of online voter registration. As far as proving residency, if you register to vote in person, this could be on election day or it could be earlier. The main statutes that currently exist give the registrar several different options for materials they can rely on in deciding that you are a Maine resident or a resident specifically of the district you want to vote in, that you're applying to register to vote in. And this decision is exclusively within the registrar's discretion. But what the statute says is the registrar may consider the location of the dwelling that the person currently occupies, the person's receipt of public benefits. If those benefits are based on residency, the registrar can consider that as proof of residency, or vehicle registration location. The registrar could alternatively rely on the residence address where the person receives mail, or the residence address listed on the current income tax return, hunting or fishing license, driver's license, or non-driver identification card of the person who's applying to register. The registrar could also rely on the voter's sworn statement of an intention to reside at a particular place. And that's actually provided in a different law, that sworn statement. So I gave you a separate link there because I didn't want you to think I was making that up. That's over in 121. Additionally, the current law says that the registrar may consider this sort of a catch-all phrase, any other objective facts tending to indicate the person's place of residency. So those are the options for the registrar if you apply to register in person. If you apply by mail, if you look at the instructions, which I've linked again here, that are attached to the voter registration card, those instructions specifically tell you if you're applying for the first time to vote by mail, you're supposed to include a copy of your driver's license or other valid photo ID, or a copy of a current utility bill, bank statement, paycheck stub, or other government document that shows your name and address. Because remember, this is the part about proving your residency. If you don't include one of those documents, then you still are required to prove your residency under current law. So what happens is, if you remember, I told you that when you apply to register to vote by mail, you have to do it with 21 days or more before the election, and that gives the registrar time to mail you the notice of acknowledgement form and see if it gets returned undeliverable. If it's not returned undeliverable, according to my discussions with the Secretary of State, because I don't do this myself, I checked with them. They said the fact that that notice is not returned as undeliverable, the registrar is allowed to rely on that as an other objective fact tending to prove your place of residency. If the notice is returned as undeliverable, though, and you show up to vote, you're going to be required to prove your residency and identity when you show up to vote, or else you're only going to be able to cast a challenge ballot. So under the bill, as far as online voter registrations, it doesn't really get into the issue of proving your residency because presumably all of this is handled under current law. So under current law, your proof of residency still has to be established. Remember that the notice of acknowledgement is going to be sent to you at the address you provided in your online voter registration application by non-forwardable mail. If it's not returned, the registrar is allowed to rely on that. If it is returned as undeliverable, you're going to be required to prove your residency and identity when you show up to vote for the first time. And in addition, there wasn't really room in these boxes, but if the registrar has reason to worry that maybe you really don't have residency here, they have all of these other options, and it is in their discretion to ask you to prove your residency through all the options under existing law. But again, that's not really addressed in the bill. That's all existing law. So it's not really changed by the bill.
Great. Thank you, Janet. And Janet, can you just remind me, because I can't scroll up, when the effective date on this is?
Right now, the effective date is January 1st, 2023, but the sponsor did ask to change it to November 1st instead. And I believe that has to do with the central voter registration system update, but you should confirm that with the Secretary of State's office or Representative Peirce herself.
Great, thanks. Yeah, we can bring in Deputy Flynn, I believe, is here. Deputy Flynn, welcome. I think first, can you perhaps address the question from Representative McCrate earlier about victims of domestic violence and maintaining privacy on the voter lists? Do you know that off the, yeah.
Yes. If someone has joined the address confidentiality program, they register with their ACP number that they're issued by the entity, whether it's the shelter or there are certain entities that will issue the credential to the voter. And we'll have to discuss how we do that because they'll be entering an ACP number rather than a name, and they'll be using the main Secretary of State's office mailing address. We have a special mailing address, so all their mail gets forwarded once they join the program, comes to the Secretary of State's office, and then it gets forwarded on to the voter. But I think we can incorporate that into the online form.
Sorry, I was on mute. Thanks. And did you have any follow-up, Representative McCrate, or is that?
No, thank you. That's just what I thought, and I think it can certainly be done. Thanks.
Important. And Deputy Flynn, so your recommendation was to move this till November of 2023. So is
Yes,
that the general timeline for the upgrading the CVR?
That's right. And we've started working on the request for information and gather that information this year about what systems are out there for new central voter registration systems, and then do the RFP. And we expect to be, our timeline has us finishing that in 2022, contracting with the selected vendor, and then implementation in 2023. And that will involve some customization because we have specific processes that are in Maine law that we have to, any software is designed a certain way, and there may be things that we'll have to customize, including implementing the online voter registration component.
Right, thank you. I think that was, part of the reason why I've actually voted against this bill in the past, was that we knew this upgrade was coming, as well as the bill previously for ongoing absentee, that this is something that could be built into the CVR program so that it can be streamlined and consistent across the state.
That's right.
Can you, I guess, just address, if we had a number of questions about how people would submit their signature during the public hearing. Can you kind of walk us through what other states do, if you know, or and same with you, with Emily as well? I know you both have worked on this information requests on what other states are doing or how they accept the signature.
What we're doing, a little bit of it is going to be technology specific, depending on what we have for CVR. But I think other states are either allowing them to upload a scanned image of their signature, or take a picture with their phone and sending in as a JPEG image or a photo image. We're obviously looking at it to make sure that it is, meets the requirement of being, legible. That's in the law. But I think some of that is we'll be able to develop that better in the rules as we see what kind of system we're using when we're acquiring for the CVR. And we don't want to be completely specific because obviously technology is changing over time, and we don't want to put something and say we're going to do it exactly this way, and then it doesn't leave room for you to change with evolving technology. So.
Right. And so just if somebody were to show up at the polls who, tried to register online and they didn't have a signature on file, that would not be considered a completed registration. So that person would have to do like a challenge ballot or something, or produce a
signature. Or they could complete an in-person registration right there.
Right. Okay. So that's something that needs to happen before they're able to vote, though. I think, is that correct? That was one of the concerns that I heard.
That's
okay.
Right.
Senator Farron.
Thank you, Mr. Chair. I think you answered my question. I was just with the conversation we had a couple of days ago, I want to make sure that we're talking about showing a valid ID at the polling place to be able to register and do that. So, thank you.
Yeah.
Well, I wondered if I could just mention something as I was watching the walkthrough. I think there is I guess maybe typo. There's a couple places where it's referred to as a driver license or non-photo identification. And I think that should be non-driver identification. That's a state ID card. It is still a photo ID, but I just wanted to, so that your work will correctly reflect that.
Sure, thanks. And I think the plan was just to get started today because it is a new system, and we would kind of work through some of the issues and then give people a little more time to develop it. I know that was kind of requested at the public hearing.
It's a lot of information in a few days to pull together.
Yeah,
so.
it is. And I know that was brought up at the hearing, so I'm fine to give more time. Representative Corey.
Thank you. I'm just going to be straightforward, and I'm going to say that, probably my biggest stumbling point on this bill is that, we won't have a physical signature on hand. Like, I heard, this Ms. Flynn say that, that technology, changes, and that's why we need to, be flexible in statute with this. But sort of my idea surrounding it is that yes, technology changes, but a signature on paper doesn't change. It always kind of is what it is. I've been doing graphic design work or, design work since I graduated from college in '97. So, almost 25 years. And it's funny how much even a digital image of a signature has changed in that time. So what used to happen is, we would sign a piece of paper and somebody would come in and we would do something called a bitmap scan, of that. And that's already a facsimile of that signature. But we also had scanners in our office where we could do 600, DPI line art, scans in order to, make that signature as reproducible as possible. And, it was really kind of only people in my field that were, doing that kind of stuff. From there we went to, and this was in the day even before we had digital, cameras really. So, everybody had a desktop, scanner in order to, get that absolute best quality scan. Well, things have changed. People are now doing, digital cameras because, they no longer need to scan in their photos to share them or, put them in print and everything else. So people, now that, probably since the, I don't know, like maybe 2006, 2007 on, people have, digital cameras, and there's quite this, library of digital images now. But what happened in the interim is that these desktop scanners, have started to disappear, and the capabilities just aren't there the way they used to be. I've been thinking a lot about how to, get so I think what I'm getting at is that I don't think that the digital images of signatures, especially one taken with a cell phone, is getting any better than what we were doing 20 years ago when we were scanning images. I actually think that the image quality has gone south, significantly south. So I've been thinking a lot about like how we could do this, how we could get a physical signature in place. And we've got the requirement in this bill that we send a card to the person's house to distinguish whether or not they're actually living there or not, you know. And I thought, well, why don't we just have that person sign the card and mail it back to, you know, the town clerk, rather than, you know, letting it either, you know, lie and, you know, be bounced back, you know, to the town clerk to tell them that somebody's not actually living there, or but anyway, so we're already mailing to these people. So my thought is, you know, again, if they sign that, if we put, you know, those the return of those signature cards on sort of like a provisional, you know, registration, you know, we still get all of the things that we want to do with, you know, digital online voter registration, like, you know, increasing accuracy of, you know, input when somebody inputs their own information through a digital system, you know, the idea that, you know, they could still, you know, upload, you know, a version of a signature, a facsimile of a signature, but not the signature itself, to kind of hold that place temporarily. But, you know, ultimately I can't vote for this bill if we're not requiring an actual, you know, physical signature to be sitting there and compared, because, you know, as you know, the deputy secretary of state said, you know, technology changes, but, you know, physical signature does not change.
Yeah, I am. Thank you, Representative Corey, for that question. I think the issue we would have with that is that means that this wouldn't be online voter registration system. We'll be mailing to people who aren't proving their residency through their driver's license or state issued photo ID number or their social security, or sorry, Julie, correct me if that was wrong, but we're trying to do online voter registration, not a hybrid online mail system.
I would like to add to the acknowledgement notice required under the Help America Vote Act is to let the voter know that whether their application has been accepted or rejected. And it may be that we're sending them an acknowledged notice to reject it because they haven't provided an uploaded signature, or they haven't provided a driver license that can be matched, might match their identity, but not the residence. And it also is to provide the location of where the voting place is for that voter. So it's an informational notice. And I would echo my colleagues' comments that, you know, that really is a hybrid system. It's requiring the paper mailing to come back, which there may not be time to do that. Acknowledgement notice gets to them, you know, a week before the election. They may not be able to get it back in time for it to be on for election day.
And Julie, nothing would prevent, I guess, somebody from going in and signing something in person, right, with the clerk?
That's right. And the clerk could have the application there and ask them to put their cursive signature on it, an ink signature, or sign another application.
Right. And if somebody requested an absentee ballot who hadn't provided a signature, they wouldn't be able to get one, right?
I think that's right.
Because they wouldn't have been registered fully, I guess.
Right. That's right. If we're not going to accept that online application, we'd have to notify the voter that it's not being accepted because they haven't uploaded a signature if they only provided the last 4 social.
Representative Corey, did you have a follow-up?
Yeah, no, I mean, I was just, again, going to make more of a statement. I really wasn't asking a question the first time or anything. But, you know, I wasn't talking about, if a physical signature, 15 days prior to an election wasn't provided, that would somehow kick that registration out. What I was saying is that we would create a provisional period, do you know what I mean, by which they would return a card with a physical signature to the clerk. And, to talk about a hybridized system, we're going to have a hybridized system, already. We're going to have a CVR system with signatures for some people in it, right, that have voted online. And then we're going to have another hybridized system for people that have registered in person. Granted, all their information will be in the CVR, but it's not like we're lifting those signatures off of each and every one of those current voter registration cards sitting in the clerk's office and putting those signatures into the CVR from my understanding. So we're going to have a hybridized system, whether we do an online voter system or if we go with the current system we have. And so
if I may, I just would like to say that the system originally, all the cards were scanned and the signatures are pulled off the application and put and saved in the system. The problem is, which is one of the reasons why we're going out to update our CVR system, is the current system is very browser dependent, and that has caused some problems between the scanning technology, the scanners, and the system. So there are some towns where they've been unable to scan their current cards, but the expectation is if they can scan, they should be scanning the card, and that pulls the signature out and saves it in a separate spot so that it can be viewed separately.
It seems like they should be scanning the card just so that if the town hall burned down, do you know what I mean?
Yes.
Another record of what was there. It seems like, but it's
Absolutely.
still a hybridized system where we have a physical signature for some people and we don't have a physical signature for other people. So,
okay. Representative McCrate. Oops. Yep.
Thank you, Mr. Chair. I just wondered if we could bring the sponsor in on this issue.
Sure. Did you have a question for the sponsor?
Well, I just wondered if she could respond along the lines of the statement that Representative Corey was making about altering this with some sort of card.
Sure. Representative Peirce. Yep. Welcome.
Hey, thanks so much. I've been listening to all of your bills. It's always fascinating to sit in on your committee and appreciate, first of all, the analysis done by your analyst was just great. And I appreciate that. And I certainly appreciate the Secretary of State's office being here because they're really going to be on the front lines of implementing this. And so I don't think of it as a hybrid system. I think of it as a system that offers every voter an opportunity to register to vote in the most easy and effective way that they want to do it. Right. So if you prefer to walk into your town office or maybe you don't have broadband that's accessible for you, you can continue to do that and you'll fill out those forms. If you want to do it by mail, you'll do out those forms as well. And if you want to do it online, you'll fill out those forms as well. So all it does is just then all of the information hits the town clerk and they have that information. And I fully expect, because this has been done in, as we saw, 38 states and DC across the nation, that you would not be given the opportunity to be a voter unless all of your information had been filled out correctly. And that would include your signature being, legible and readable and an ability to have that be valid. So I have every confidence that our SOS office will look at what's been done around the nation, look what we're trying to do with the CVR, and coordinate those things in an effective manner. So I see it as just giving the voter one more tool to be able to register to vote or to change their address should they move, or if they got married or divorced, whatever that might be. So it's just one more tool in the toolbox for the voter to be able to get on board to do this. And I did also want to highlight, I took great care in hearing what the clerks had to say and their concerns. And I think the concerns of the clerks were really addressed in the amendment around that. So I hope that you'll give the amendment some time and attention as well. And that was worked. I did that in conjunction with the Secretary of State's office too, because we all want to be kind of, in singing one chorus, so to speak. But I think all the questions are great. This is a great conversation. And I hope that through that analysis, we saw that really we're doing things exactly the same. It's just another venue for being able to register yourself to vote. So thanks for bringing me over and
Sure. Yeah.
putting me in the ether and bringing me back and over and around. So
Yeah, you get stuck in the middle for a little while.
yeah, you do. Yeah.
Representative Dolph.
Thank you, Mr. Chair. I know you're thinking of it as another tool. I have a really big concern with talking about signatures, but I'm concerned with citizenship when we're doing something like this.
Well, thank you for the question.
It's just a statement, I guess.
Yeah. Okay, so Julie, under the HAVA Act, that is one of the required questions, right? That you're a U.S. citizen.
Yes. Yes, if you answer it in the negative or you don't answer it on paper, your application is rejected. And with AVR, and we anticipate with OVR, that the data comes over, like when there's a driver license, the data comes over and it gets matched to the motor vehicle, and they will verify that citizenship is met and that the address matches and the name matches, and that information will be available when the record is presented to the clerks for review. It's important to note this is not going to be a system-to-system transfer of data. Nothing goes automatically into the database. It's going to be reviewed because, first of all, you need to see whether that voter's registered somewhere else, and it's an update to the system rather than a new registration, which is what happens when you get a paper record. So.
Okay, great. Any other questions for this? I know we wanted to do like a quick early work session as people had requested, rather than try to force it to move. Representative Wood.
Thanks, Mr. Chair. I'm just, I'm trying to understand how all these different things work because I haven't registered to vote for 35 years. But this system that we now have, the automatic voter registration, I had Secretary Bellows explain that to me a few bills back because I'm not familiar with it. But if you go into DMV to get your driver's license, there's some kind of computer set up that you can register to vote. That's what the automatic voter registration is, right?
Well, Julie can speak better to that, but we don't have it implemented yet. We've got the law in place and it's going to be implemented in the future, but Deputy Flynn can probably address it.
But that's how it's going to work. And so then I'm trying to understand, how does the signature happen in that system?
If the person already is a driver and they're just making an update to their driver license or state ID, then there already is a signature on file. And that signature will come over with the data that you're entering. If it's a new voter, they'll be able to sign, and a new driver, they'll be able to sign the record. They're looking at, a keypad and something that processes credit cards as well as inserts some additional information and presents the disclaimer that they don't want to opt out and they want their data for motor vehicle to be used for the voter registration portion. So currently we're required to provide them an opportunity to register on paper. So automatic voter reg is really going to be an efficiency,
right, but that's
replacing
what I'm
that
saying.
paper.
Okay, Representative Wood.
When it goes into effect, though, will they still have to sign a piece of paper or will it all be done over the computer?
The data will transfer in the back end of our system. Our systems are already talking to each other because we're part of the same department. The data will come from the motor vehicle temporary file and go into the central voter registration system. And there'll be a holding area until it's determined and looked at by the applicable town. So, I mean, I can tell you exactly how it would work with the current CDR system. It's probably going to be a little bit differently when we upgrade the software, but currently they would get a notice in their dashboard essentially, and when they open up in the morning, they can see, currently they have notices that they've got vital records to review to see whether there's any deceased voters, and that's already built into our current CDR system. So I'm anticipating there will be something similar to that with whatever new system, so that they'd have a list of, there's 10 automatic voter registrations waiting for your review, or there's 15 online voter registrations waiting for your review. So these are all things that would be staged, and they would see the data electronically and the signature as well.
Thank you.
Any other questions at this point for any of the panelists? Okay, seeing none. Representative Chiazzo.
Thank you, Mr. Chair. I move we table LD 1126.
Okay, we have a motion to table LD
Second.
1126, seconded by Representative Chiazzo, seconded by Representative Tuttle. We can do this vote by a show of hands if that's easier. So I won't do the thumbs up, Representative Corey, but I'll do hands. So we'll go, all those in favor, if you can just hold them up for a minute of tabling this bill. We got 1, 2, 3, 4, 5, 6, 7, 8, 9. Okay, those opposed, 0. So it's unanimous of those present. So thank you to everybody for your participation today in this bill. I know we have, I think, Janet, we have 2 bills that popped up from the revisers for language review. Is that right?
Close.
Close, okay. Oh, right, my bad. Yeah, so we do have also Director Champion here. He's one of them is on the online raffle bill. I know there had been some concerns, and where we had voted by bullet point, we just wanted to give everybody a chance to look at the language, and we won't report it out or anything, but we just wanted to do a preliminary language review, and Janet got it ready for us very quickly. So
Right, so there are 2 language reviews, one's preliminary and one's from the revisor's office. So you want to start with the internet raffles?
please, yeah.
So if you're really interested in how our job works, this is the way we draft amendments sometimes to the revisor's office. So this has been sent, but it hasn't been processed by them yet. So this is, when I drafted it, I didn't have the final vote, and I wrote that it was a unanimous committee amendment. It is no longer unanimous. It is an 11-to-1 vote with 1 person absent. So this would be changed to be a majority committee amendment, just so you know.
Was the one ought not to pass, or?
Correct.
Okay, thanks.
I have the voting sheet here somewhere. I believe it's ought not to pass.
That's okay, yeah.
Yep. It's Representative Dollop ought not to pass.
Yep.
So the first part are just additions to the definitions provisions for the games of chance statutes, which include all of your raffle statutes. I thought it was clearer to call it an internet raffle operator instead of an electronic raffle operator. If you don't like that, you can direct me to change it back. It just made more sense to me. That was more stylistic. It didn't actually change the substance. So we would define what an internet raffle is, which is where you purchase the chance or ticket online in some form that uses the internet. The internet raffle operator is going to be a person, firm, corporation, or association that's licensed under this new licensing procedure to conduct those internet raffles using a system that's been approved by the Gambling Control Unit, and that's going to be called an internet raffle system. This new licensed entity, the internet raffle operator, The fee for that license is $500 a year. And so that's just plugged into the fee statute that's in current law. This next thing is just a little revised office styled kind of technical change. Doesn't really change anything. It's just when there's a cross-reference, you need to make sure everything works. 1835A is a provision of law that talks about how games of chance, including raffles, are conducted. And under current law, it requires all games of chance to be conducted by the organization that's offering the game of chance, or a bartender, for example, that they have. So you need to have an exception that allows the organizations that are conducting internet raffles to use this new licensed entity called an internet raffle operator to conduct the raffle, because it's online. And so that's all that this provision is doing. It's saying, okay, yes, all other games of chance have to be operated by the members of the organization that are sponsoring it, but you can use an internet raffle operator if you're doing an internet raffle. So 1837 is a provision of law that talks about registrations, and this just had an incorrect cross-reference in it. It didn't make sense, so sorry, it's hard to go back and look at this. Now I drafted this a couple of days ago, and that's how much I do in the meantime.
That's all right.
In the middle. Let me just pull that statute. Can you hold 1 second?
Yep.
Here it is. 237. That's the wrong section. That's why I'm confused. I'll get back to you on that. I think it's just correcting a cross-reference, but I'll make sure.
Right, and this is just preliminary too, so we can check that
1837 is the provision of law that currently governs all raffles that are conducted in Maine. And so if you remember, I showed you a chart during the bill analysis, during the work session, that talks about if it's a less than $2,500 prize, any organization in the state, doesn't matter who you are, can offer that raffle. They don't need to register. So you can have a raffle of $2,500 or less total value, no problem, no registration. Current law does have two provisions that talk about eligible organizations. Those are your charities that we talked about at the work session, and they're allowed under current law to offer raffles of prizes with $10,000 or less. If they do that under current law, they don't have to register. They also have the option of offering raffles with higher prize values, and if they do that, they have to register. But you instructed me to draft an amendment that said, if you're an eligible organization and you're conducting an internet raffle, no matter the prize amount, you need to register with the Gambling Control Unit. So that's what this provision is about, because ordinarily, if it's a $10,000 or less value raffle, you don't have to register. So this is just providing an exception that if you have an internet raffle, you do need to register. So the sum total of this is any eligible organization that is offering an internet raffle will be registered with the Gambling Control Unit, so the Gambling Control Unit knows that that internet raffle is occurring. Here's the provision that's going to be created directing that. So it's going to say that an eligible organization, and it's defined in 1832-2, that's your eligible organizations that are charities or agricultural societies. If they want to conduct an internet raffle, they're going to be directed by this portion of the amendment to register with the Gambling Control Unit, and they have to operate their internet raffle in accordance with the requirements, all of the requirements for games of chance. And they have to have an internet raffle operator that they identify on their registration form. Remember, this internet raffle operator is the new licensee that actually has the computer software that runs these internet raffles. So they need to write on their registration form, tell the Gambling Control Unit what licensee they've chosen to provide that service. This also specifies that they can't permit anyone under age 18 to purchase a chance or ticket for that internet raffle, and they can't advertise or market it in a manner that would have a high likelihood of reaching persons under 18 years of age, or that is specifically designed to appeal particularly to persons under 18 years of age. This language I stole right out of the adult use marijuana statutes about the prohibitions on advertising. So it's language that has been used before when you don't want advertising targeted to minors. So then there will be a new statutory section created, which talks specifically about these internet raffle operators and their licensing. So the first provision just says you're not allowed to operate the internet raffle unless you have this license, and you can't do it unless you are providing it on behalf of an eligible organization. So this amendment says you can't just be an internet raffle operator and start offering them for everybody. You can only do it on behalf of the eligible organizations, and those are your charities we talked about before. So as far as the licensing provision, the Gambling Control Unit would be able to issue that license to any person or business entity, but they can't issue it unless the business entity is organized under the laws of the state or has an authority to transact business or conduct activities in the state. The reason for this second requirement, the second phrase, is once you have authority to transact business in the state, that means you have a registered agent within the state that serves a process, which means somebody trying to institute a lawsuit, they can serve you and get jurisdiction over you. So that's why that provision was included in there. It was part of the amendment, but I just want to explain what that means. So when they apply for their license, they have to include the following information: the name, primary business location, and contact information for the applicant, who could, as I said, either be a person or a business entity. They have to disclose any person that owns 10% or more of the equity or voting shares, or is able to control the activities of the applicant, or anyone who has directly or indirectly holding an interest in a non-corporate applicant's business operation, or has the ability to control the business operation. All of this language is similar to language that was used in the sports betting bill reported out by the VLA committee in the 129th. Both the majority and the minority amendments had that language, so it seemed useful people to identify in the application, as well as key personnel. And your key personnel are your officers, directors, managers, or general partners, and each executive, employer, or agent that has the power to exercise significant influence over the decisions. Now you may ask me, why is all of this disclosure required? And that is because you're then consenting to permit the Gambling Control Unit director to conduct a criminal history record check for all of those persons if he so chooses to do. In addition, the applicant has to disclose to the Gambling Control Unit when they apply for their license, if they've ever had their license for gambling related licenses revoked or suspended in Maine or any other jurisdiction, or if there's been an adverse action, for example, the imposition of a penalty, or they voluntarily surrendered their license. So that's information the Gambling Control Unit can consider and whether to grant the license. And then if the Gambling Control Unit chooses to do so, they can by rule require other additional information, but it's not a requirement. This bill could go into effect before any rules are adopted, and then just the information required in the statute itself would be on the application. The next portion of the amendment allows the Gambling Control Unit director to conduct a background check. When you see other background check laws in the future, I know that we have some sports betting bills that have been printed already that have some background checks. They have much more than this language for a background check, and that's because those are fingerprint-based background checks. In order to comply with federal laws and state laws, you need a lot of language and a lot of information to conduct fingerprint-based background checks. But the Gambling Control Unit director said he didn't necessarily need to do a fingerprint-based background check. He just wanted to check the criminal history and make sure that there wasn't a problem that would prevent him from licensing these entities or persons. So then, in addition to licensing the business itself, the system it uses, so the computer software and the programs it uses, also have to be certified. So this provision says that the operator can't conduct the internet raffle unless that system that they use has been examined, tested, and certified either by the Gambling Control Unit itself or an independent testing laboratory that the Gambling Control Unit has approved of. And the cost of that testing and certification are paid by the applicant. So before their system, their software system can be approved, they have to demonstrate that it prohibits someone from purchasing an internet raffle ticket unless they have an account into which they deposit funds that are used to purchase the chance or ticket. The purpose of that is so that they're not having credit extended to them or using a credit card to buy the ticket, because that was your direction. So instead, they're going to deposit the funds into account. Now they have money stored with the operator, and they can use that money to buy the ticket instead of a credit card or some other extension of credit. The amendment also requires for the system to be certified and approved, they have to ensure that the system prevents someone from opening that raffle account or purchasing a ticket for an internet raffle if they're under 18 years of age. If somehow the person slips through those controls and buys a ticket, the system must provide for immediate refunds of any payment to purchase that ticket to someone whom they discover is under 18 years of age. And the system itself must facilitate and advertise the use of parental controls so that adults can exclude minors from accessing the system. The system must also be shown to determine and verify that someone who purchases the ticket for the internet raffle is physically located within the state at the time the purchase is made. Sometimes this is referred to as geolocation software, so that has to be built in. That, if you want to recall from the work session, was to protect the eligible organization offering the raffle from not accidentally running afoul of laws in other states where the person buying the ticket is located, because under federal law, you have to make sure that the state where the person buys the ticket and the state where the ticket is being sold, that both states' laws allow the internet raffle. And as you know, the laws of these different states totally vary. So this is a protection sort of for the eligible organization, has to be built right into the computer system. The system must also be shown to select the winning chance in the internet raffle by means of a cryptographically strong random number generator. I'm not entirely sure what that is, but that is language I was given. So please don't ask me what it means, but it sounds very protective. The system also must be shown to protect the privacy and security of the raffle account owner's information, and all of the owner's accounts that are maintained or accessed by the internet raffle system. So for example, if you open an account so that you can buy internet raffle tickets and you give the system information on your own bank account so you can transfer money over, all of that information has to be protected, and it has to be protected in a way that satisfies the gambling control unit or the independent testing laboratory. In addition, the system must maintain records for 3 years of the winner or winners that have been selected. There also has to be records maintained about all the people who purchased a ticket for the internet raffle, and a copy of those lists and an exact accounting of all the revenue has to be transmitted to the eligible organization on whose behalf the internet raffle was conducted. So when they're approving the system, they have to make sure that all of those functionalities exist. And then if the gambling control unit chooses to impose additional requirements, they can do so by rule, but unless and until they do impose those rules, then the statute would just require these requirements. And then Section 1838 of current law talks about the proceeds of any game of chance, including a raffle. The way the law is currently written, with very few exceptions involving agricultural fairs, you're not allowed to pay the people that conduct games of chance. But because you're requiring eligible organizations to hire this licensed internet raffle operator, they are, just the way the market works, going to have to pay them something, or else they wouldn't be willing to offer this service. And you directed that they be told that they can't pay them more than 10% of their internet raffle proceeds. And the director champion who proposed this provision said that this was sort of a protection for the eligible organization to make sure they aren't being price gouged or anything like that.
Great, thank you, Janet. So yeah, we just wanted to give everybody a chance to see the language, take it back to people. I know there had been a couple of concerns since the work session that were raised, so we just want to give people a chance to look at it before we do a an official language review, and obviously Chris and I won't send this out until we give everybody a chance to look through it and take a look and give some input. So, yeah.
I did figure out what this is here. This was the part I skipped. It's because there's supposed to be a -A here. It's 1837-A. So these are the two provisions of current law that allow eligible organizations to conduct raffles. And so it's just saying if you're having an internet raffle, make sure you follow the internet raffle rules. So they're just kind of cross references. So sorry about the missing -A. I am sure the revisor's office will correct it.
Well, I caught that too, so.
You
Representative
just let
McCray,
me look funny here.
I was thinking it was a -A, but I don't know.
Very smart of you.
Representative McCray, did you have a? Oh.
Yeah, I just wanted to ask Janet, on the background check, if the director felt that there was a need to do a fingerprint check, is that allowed or just not needed or not considered?
If you need to do a fingerprint-based background check, you need to have authority under the law. So this law doesn't allow for that. There are a lot of requirements that you have to follow. So I believe he offered to be here. I hope he is here. He is, if you want to ask him about the differences there. I just had to guess because I had posed the question early on in the work session and forgot to clarify when you voted on the amendment, whether you wanted it fingerprint-based or not. So I just guessed not fingerprint-based, but it's really not up to me.
I just brought in Director Champion if he's here. If you want to just comment on the fingerprinting thing. I don't know if you heard the question from Representative McCray when I.
Yeah, I did. One alternative that we can do in lieu of going through us actually doing the fingerprint background check themselves is we have the applicant submit a criminal check. So they can get that and that'll be part of the application. And that's a lot easier to do versus us getting those fingerprints through the system.
Great.
And just to follow up.
Yeah.
So Director, are you talking about if you felt the need for that, you could have for a fingerprint check, which is a federal rather than a state check, you could require that of the applicant?
Absolutely. Yeah. Janet would have to put that into the law, but yes, I'd be able to do that. Is that correct, Janet?
Right. I think what you're both saying is if you want to require by statute that it be part of the application, we need to change the amendment and require a fingerprint-based background check that the gambling control unit would conduct. But if you instead, Representative McCray, think it's okay for the director to require them to submit their own results so that nobody's collecting their fingerprints. So you don't need all of those extra statutory provisions because we don't have their fingerprints ourselves. But the director could decide by rule under the amendment to say, no, I'm going to require you to submit your own results that you get from the FBI so that I don't have to collect your fingerprints to get those results.
Yeah, that makes sense to me. Thank you, Director. And Janet.
You're welcome. Yes.
Great.
-A.
Anything else? Yeah. Anything else for this one? I know we're not going to report it out or anything. We'll give people time to work through the language and see if they notice anything, and then we'll take it up again in the future. Okay, great. Representative Tuttle.
I've got a 10-page speech that Representative Chiazzo gave to me. I didn't know if I could read it now.
A what?
Just jokingly.
Okay. Yeah, that's right. Sorry, my internet has gotten really bad.
We do have another language review if you want.
Okay, can you hear me okay?
Yep.
Yep. Yeah, I think we had 671. Is that right?
That's what this is.
Oh, sorry. We have Representative Moriarty's bill. I forgot the number. I only have one screen today.
It's 580.
580.
Let me get
I try not to cross Representative Moriarty. So
That's not very wise, Mr. Chair.
a very fast runner. So, yeah.
So LD 580 is a resolution proposing to amend the Constitution of Maine regarding early voting. If you look at LD 580, all of that text will stay the same. There was a divided vote. The majority report was ought to pass as amended, with the amendment only being the fiscal note. This amendment should not surprise you because you've seen this type of fiscal note before. So this fiscal note will say that if there are enough referendum questions on the ballot so that you need a second ballot page to be printed, there may be additional appropriation required for the additional printing and delivery costs. And the actual vote on this amendment is here. It was 8-5 of ought to pass with just a fiscal note amendment, and then the others voted on not to pass. If you wanted to remind yourself, this vote was taken a long time ago. Sorry it took so long to get this fiscal note to you. There was a logging error in the system, likely caused by my scribbly handwriting when I gave it to the secretary.
Great. Any questions from those who are in favor, I guess, of the language? It looks good to me. Any, the fiscal note, that is. Okay. Seeing none. Is that it today, Janet, for
You will be
language?
very relieved to hear yes.
Okay. It is a beautiful day, looks like outside. Okay, yeah, I think that's it for today. And then we've got Monday. More, wait, is this week Monday the holiday, or is it?
No, Monday is not a holiday.
Not a holiday. We have a meeting Monday, the following one.
Hearings starting at 9.
Okay, so Monday at 9, we'll see everybody. Anything else before we adjourn? Hope everybody has a nice weekend, and thanks for your work today. So, all right, we'll see everybody on Monday.